Ako na, Mami.
Start na.
Good afternoon, fellow advocates of law. To open our webinar, let us all stand for our national anthem. Please remain standing after the national anthem for our prayer to be led by Attorney Constantino Banjo Navarro III, trustee of the San Beda University Alumni Foundation. Let us all stand.
Tupo tayong lahat, ilagay ang kanang kamay sa ating dibdib at sabay-sabay nating awitin ang pambansang awit ng Pilipinas.
Bayang magiliw, perlas ng silanganan, alab ng puso, sa dibdib mo'y buhay. Lupang hinirang, tuyang ka ng magiting, sa manlulupi, di ka pasisiil, sa dagat at bundok, sa simoy at sa langit mong bughaw, may diyak ang tula at awit sa paglayang minamahal, ang kisap ng watawat mo'y tagumpay na nagniningning, ang bituin at araw niya kailan pa may di magdidilim. Lupa ng araw ng walhati pagsinta, buhay ay langit sa piling mo. Aming ligaya na pag may mga api, ang mamatay ng dahil sa'yo.
Maglalag doon sa mga iba, maghihintay ka ng oras.
Banjo, you may now lead our prayer.
Let's all put ourselves in the presence of God. Almighty God, our Heavenly Father, we come before your throne of justice, your throne of mercy, and your throne of wisdom. Even as we partake of this Zoom teaching to be led by Judge M.Gito. Thank you, Lord, that the foundation of your throne is righteousness and justice. Lord, I pray for all the participants, those who are listening and watching, that you would open their eyes and their ears, that they may absorb whatever Judge Gito may share to us. And we especially lift up to you, Judge Gito, as he simplifies, explains to us all the new amendments to the 1997 Rules of Civil Procedure. Thank you, Lord, that as lawyers, we are all vessels of honor to promote righteousness and justice. Thank you, Lord, that we will apply whatever we learn today. Thank you, Lord, that all the participants will be able to absorb and even teach and share to others what they understand. Lord, we lift up to you San Beda Law Batch 85 for hosting this Zoom meeting. Thank you, Lord Jesus. In all of this, we bless our afternoon and we speak protection from all the COVID virus around us. Thank you, Lord, that peace, good sleep is available because you never change. You are a God of justice, mercy, and love. All of this we ask in Jesus' name. Amen.
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 Thank you very much, Attorney Banjo. In behalf of my San Beda Law Batch 1995 classmates, I welcome all of you to our webinar. We hope that through this webinar, which is new to majority of us, we are able to help you adapt to the new way of doing things. Thank you, Pañeros and Pañeras, for joining us. Later, if you have questions, you have two options. You may either click the Q&A button and write your question, or you may raise your hand button, and our moderator, Attorney Christopher Cruz, will call you. The raise your hand button and Q&A button are located on the right topmost part of your screens. We would like also to thank Ayala Corporation, its General Counsel and Corporate Secretary, Attorney Solomon Mon Hermosora, our law professor, and Ayala Corp Chief Information Officer, Gavin Barfield, for hosting our webinar. At this point, we have already 422 participants. So far, according to Judge Siner, this is the biggest webinar that he will be holding. At this point, allow me to call our classmate, Muntinlupa City Chief Prosecutor, Eileen Gutierrez Marcon, to formally introduce our lecturer.
Thank you very much, classmate. Thank you very much, Winston. Good afternoon, ladies and gentlemen. I was given the privilege of introducing our lecturer, whom I have known for more than 20 years. He obtained his Bachelor of Arts in Political Science at the University of Batangas and Bachelor of Law at San Sebastian College, Recoletos. After law school, he clerked for our professor, Justice Romeo J. Callejo Sr. at the Court of Appeals. He went to private practice and at one point became a politician. Thereafter, he joined the Senate of the Philippines, where he became the Chief of Legal and Legislative Affairs Service. He returned to the judiciary as presiding judge of the Regional Trial Court, Balanga City, Bataan. Prior to his appointment as presiding judge, we were classmates for 2 weeks at the Pamantasan ng Lungsod ng Maynila Graduate School of Law, where he obtained his Master of Laws. He pursued further studies and became a Doctor of Laws from the University of Santo Tomas Faculty of Civil Law. In both endeavors, he obtained the highest ranking in his thesis defense and dissertation. Our lecturer was a member of the faculty at De La Salle University, College of the Holy Spirit, Far Eastern University, San Beda College, Universidad de Manila, and Polytechnic University of the Philippines. He is a pre-bar lecturer and also a lecturer at the Philippine Judicial Academy. Recently, he was appointed as presiding judge of the Regional Trial Court, Branch 206 in Muntinlupa City. Ladies and gentlemen, colleagues, the 2019 Judicial Excellence Awardee, the Honorable M.Gito.
Thank you, Chief Eileen, for such a heartwarming introduction. You know, your good words about me are to be expected, considering that you are a very good friend of mine way back. And I am pretty sure that all the words that you say about me will surely uplift my spirit. Before I start, I would like to thank the organizer of this webinar, the 1995 batch of San Beda College of Law, headed by their president, Attorney Winston Hines. With this project of yours, you have done great service to the members of legal profession. I think that as what has been said by Attorney Hines, this is actually the largest virtual congregation of lawyers during COVID season, and special thanks to Attorney Mon Hermosura and Ayala Corporation for hosting this seminar. For the information of everybody, Attorney Mon was my former professor in San Beda. He is one actually of my favorite professor because he was one of those who gave me the highest grade. I think he gave me a grade of 76 in corporation law. But levity aside, it really feels daunting to speak before a Bedan community and also my colleagues in the judiciary, considering, of course, with respect to the Bedan community, your predilection for academic excellence. And I must admit that I feel a little bit apprehensive. This is most especially so when one of my attendees is my wife, Judge Emily M.Gito, a Bedan lawyer and accomplished magistrate at that. My only request to my wife is, if you're going to ask question, please do it after the seminar. Okay, I would say by way of introduction that the amendments that was introduced to the 1997 Rules on Civil Procedure will have a tremendous impact, or should I say, will change the landscape of civil litigation in the Philippines. I must say that at this early, the objective of the amendment is perfect and timely, and the amendment will surely cater the speedy disposition of civil cases. I think the Supreme Court must have taken inspiration from the result of the implementation of the guidelines for continuous trial in criminal cases. When the guidelines for continuous trial was implemented in criminal cases, the resolution of criminal cases were actually it was disposed in a very expeditious manner, and this is precisely the reason why amendments were introduced to the 1997 Rules on Civil Procedure in order to expedite the resolution of civil cases. I prepared a slide here, okay, which will guide us in our presentation, and let us start. By 3:30, we will have a short break of 5 minutes for us to attend to our personal needs. Okay. So I have titled my presentation as Matrix of Amendment introduced to the 1997 Rules on Civil Procedure. Please take note that the amendment started from Rule 6 up to Rule 35. We will not discuss all provisions. We will only concentrate on those provisions which amendments were introduced. We will do it rule by rule. Okay. So let me start. With respect to Section 1, there is no such amendment. With respect to Section 2, there is an amendment, specifically with respect to the third paragraph thereof. It is provided in the third paragraph that an answer may be responded to by a reply only if the defending party attaches an actionable document. What must have been the reason of the Supreme Court in introducing such kind of amendment? Because under the old rule, when you attach a document which is the basis of your defense, okay, the basis of the defendant's, the defense of the defendant, okay, there is an uncertainty on whether the plaintiff would file a reply. There are two schools of thought. The first school of thought is that the filing of the reply is not anymore necessary. Why? Because according to Section 10, Rule 6 of the old rule, all matters asserted in the answer are deemed controverted or they are deemed denied. So there is no more necessity of filing a reply. Even the due execution and genuineness of the actionable document, which is the basis of the answer of the defendant, is deemed denied because of that particular provision. But there is another school of thought. The second school of thought is that when the basis of the answer is an actionable document, it is the obligation of the other party to deny under oath the due execution and genuineness of an actionable document. That is actually the issue. Under the old rule, are we going to file a reply or not when the basis of the defense is an actionable document? This lacuna under the old rule is actually filled in by the present rule, Section 2 of Rule 6, wherein it is stated that if an answer is based on an actionable document and the document is attached to the answer, it may be responded to by a reply. And what is the purpose of responding by way of reply? In order to deny the due execution and genuineness of the actionable document, which is the basis of the defendant's answer. Take note that Section 2 of Rule 6 must be read in conjunction with Section 10 when we discuss the new concept of reply. So that is the amendment that was introduced in Section 2 of Rule 6. Now, we go to Section 3. There is a slight amendment, okay, with respect to the definition of a complaint. Okay? It is provided under the new rule that a complaint is a pleading alleging plaintiffs or claiming parties' cause of action. They have included, the Supreme Court included the phrase claiming parties. And that is very good. Why? Because the defendant, insofar as the counterclaim and cross-claim is concerned, is actually the plaintiff with respect to its counterclaim and cross-claim. He is considered to be the claiming party with respect to his counterclaim or cross-claim. That must have been the reason why claiming party is included in the definition of the complaint. But substantially, the essence is there. Under the old and the new, they are both the same. Now, answer section 4, there is no amendment except the inclusion of gender inclusive language. And dapat lang naman, no? Kasi naman talaga dapat maging gender sensitive ang rules of court. In fact, in the home, talagang woman naman talaga, woman actually rules. And that because of that reality, that amendment was introduced to the rules of court. All right, defenses, section 5. There is an amendment with respect to section 5. When we speak of defenses, we are told that there are two kinds of defenses, negative defense and affirmative defense. And we know for a fact what an affirmative defense is, that it is a specific denial of the material fact alleged in a pleading. There is another kind of defense, and we call that affirmative defense. Okay? Please take note that insofar as affirmative defense, both under the old and the new, there are established affirmative defense which must be alleged and set up as affirmative defenses. And what are those? Affirmative defense of fraud, statute of limitation, release, payment, illegality, statute of frauds, estoppel, former recovery, discharge in bankruptcy, and any other matter or by way of confession. These are the traditional affirmative defenses that must be alleged in our answer. In this respect, the old and the new are the same. Where lies the difference then? Okay? This is the amendment. Okay? Affirmative defense may also include grounds for dismissal of complaint. Specifically that court has no jurisdiction over the subject matter, that there is another action pending between the same parties, that is litis pendentia, and that that the action is barred by prior judgment, and that is res judicata. So what we are saying here, if you move forward, okay, you would notice that Rule 16, which is captioned as motion to dismiss, is already deleted from the 1997 Rules of Procedure. Okay? Rule 16 is already deleted. Why? Because it is now a requirement that the grounds for a motion to dismiss under the former Rule 16 of the old Rules of Court must now be set up as affirmative defenses. And generally, motion to dismiss is not anymore allowed. But there is an exception to that rule. I would like to tell that at least at this early. No? There are only 4 grounds by which a motion to dismiss may be allowed. The first ground is lack of subject matter jurisdiction. Okay? Number 2, litis pendentia. Number 4, res judicata. And number 5, prescription. These are the only grounds by which a motion to dismiss may be filed. With respect to other grounds for motion to dismiss, like lack of jurisdiction over the defendant, improper venue, lack of capacity to sue, and anything which are stated in Section 1 of Rule 16, they should now be set up as affirmative defenses. So, as I have said, the Rule 16, denominated as motion to dismiss, is not anymore part of the 1997 Rules on Civil Procedure as a general rule, because the grounds for the then motion to dismiss should now be alleged as affirmative defenses. Okay. So we go to Section 6, counterclaim. There is no amendment. Section 7, with respect to the definition of a compulsory counterclaim. Well, in substance, the definition of compulsory counterclaim under the old rule and the new rule are just the same. They are just the same. What is the difference then? Okay, they have added a sentence. Compulsory counterclaim not raised in the same action is barred. Okay? They have added that to emphasize a point. Why do I say to emphasize a point? Because there is a particular provision in the rules on civil procedure which says that is, I think, section 2 of rule 9, which says that compulsory counterclaim and cross-claim, if not set up, shall be considered barred. So what I'm saying is, even if it is not, there is no such last sentence in the definition of compulsory counterclaim, is still the compulsory counterclaim, if not set up, shall be considered barred because of section 2 of rule 9. But the beauty in the amendment is that they have added the clause unless otherwise allowed by this rule. So this will constitute an exception then. So what is the general rule? The general rule is that a compulsory counterclaim not raised in the same action is considered barred. There is an exception unless otherwise allowed by this rule. Can we find a provision in the rules of court which allows the setting up of a compulsory counterclaim despite the fact that it was not raised in the main action? I think what is being referred to here is the provision in the settlement of estate, which is provided in section 5 of rule 86. So what is section 5 of rule 86? This is what we call the statute of non-claims. And we lawyers and even law students would know that statute of non-claims is a principle by which if a claim against the estate of a deceased is not set up within the period of time set up by the court in its order or within the notice issued by the court, then it is considered barred. There is an exception, okay? There is an exception, except that it may be set forth as counterclaim in any action that the executor or the administrator may bring against the claimant. This may serve as the exception to the general rule that a counterclaim not set up is considered barred. Okay, let's proceed. With respect to section 6, the substance of section 8 of the old rule with respect to cross-claim and the present formulation of cross-claim, substantially they are the same. But if you would ask the law student, they love the definition of cross-claim under the amendment because it is easier to understand, it is easier to memorize. Look at the last sentence of the old rule. Such cross-claim may include a claim that a party against whom it is asserted is or may be liable to the cross-claimant for all or part of the claim asserted in an action against a cross-claimant. You ask the law student and it will be very difficult for them to memorize. Now, the last sentence is, such cross-claim may cover all or part of the original claim. So they just simplify the definition of a cross-claim. So, section 9 of Rule 6, there is no amendment. Okay. I just said when we were discussing section 6 of this rule, section 6 of Rule 6, that it should be read in conjunction with section 10 of the same rule. And by way of a recall, section 2 of Rule 6 is that an answer may be responded to only if an actionable document is attached to the answer. So, and it can be responded to by a reply. So what is now the new formulation of a reply under section 10? So all new matters alleged in the answer are deemed controverted. That is the same under the old rule. If the plaintiff wishes to interpose any claims arising out of new matters so alleged, such claims shall be set forth in an amended or supplemental complaint. Now, I would like to put emphasis on it. However, the plaintiff may file a reply if the defending party attaches an actionable document to his or her answer. Okay? In the event, the last paragraph, in the event of an actionable document attached to the reply, then the defendant may file a rejoinder if the same is based solely on an actionable document. So if in the reply, if the basis of the reply is also an actionable document, then it is incumbent upon the defendant to file a rejoinder. Okay? Ordinarily, under the old rules, the filing of a rejoinder is frowned upon. But this is one instance wherein it is better, actually. It is better to file a rejoinder if a document, an actionable document, is attached to the reply. Now, why do we have to file a reply if an actionable document is attached to the answer? Why do we have to file a rejoinder if an actionable document is attached to the reply? What is the effect if the plaintiff failed to file a reply when the defending party attaches actionable document upon which he or she bases his or her defense? The effect is that Section 8 of Rule 8 will operate. Okay? What is Section 8, Rule 8? This is a mandate to deny under oath the due execution in genuineness if an actionable document is attached to the pleading. What is the effect of failure to deny under oath the actionable document which is attached to the pleading? The effect is that it will be an implied admission of the due execution and genuineness of such actionable document. So what if it is an implied admission? Take note that an implied admission in the pleading is actually a judicial admission. And if it is a judicial admission, the one who made such judicial admission shall not be permitted to present evidence that would be contrary to his judicial admission. Let us take, for example, okay, the basis of the answer of the defendant in an action for sum of money is payment, evidenced by a receipt. He attached the receipt to his answer. Okay. The defendant did not, the plaintiff did not file a reply. But in truth and in fact, there was no payment. And the signature of the plaintiff on the receipt attached to the answer is a forgery. But unfortunately, the plaintiff did not file a reply. So he was not able to deny under oath the due execution and genuineness of the actionable document. What is the effect? That is an implied admission on the part of the plaintiff of the due execution and genuineness of the document which is attached to the answer. So therefore, the plaintiff cannot present evidence, an NBI handwriting expert, for example, in order to prove that the signature by the plaintiff, which is affixed on the receipt attached to the answer, is a forgery, because that would be contrary to his implied admission. Kaya napakaganda ng ginawa na amendment dito. Kapag ang basis ng answer, actionable document, dapat mag-file ng reply in order to deny the due execution and genuineness of the said actionable document, which is the basis of the defense of the defendant. Okay. Third-party complaint. Amendments were also introduced insofar as third-party complaint is concerned. But of course, we know the concept of a third-party complaint. And we also know the purpose of filing a third-party complaint. So what is the purpose? For contribution, indemnity, subrogation, and other relief. Instead of the original defendant paying, it will be the third-party defendant who will pay the plaintiff. That is precisely one of the purposes or reason for the filing of a third-party complaint. But please take note, ladies and gentlemen, that even under the old rules, the filing, the admission of a third-party complaint is subject to the discretion of the court. That is the reason why it has to be filed with prior leave of court. But under the old rule, there is no parameters on when to deny or when to accept. The discretion purely lies on the judge because there is no parameters. There lies the amendment. Under the amendment, there are parameters for the judge on when to deny or to admit a third-party complaint. So, there are parameters, as I have said, well-defined parameters set up by the new rule on when to deny the third-party complaint. Number one is the third-party defendant cannot be located within 30 calendar days from the grant of such leave. Okay. Number two, matters extraneous to the issue in the principal case are raised. And number three, the effect would be to introduce new and separate controversy into the action. If in the third-party complaint, these circumstances are present, then the judge is bound to deny the third-party complaint. But there is another question. Okay. Is it necessary that the third-party complaint must be related to the main action? Because under the old rule, there is no parameters. Whether the third-party complaint is related or not, it is within the discretion of the judge to admit the same. How about under the new rule? Under the new rule, okay? Kailangan ba na ang third-party complaint kahit pa paano connected dun sa main action? The answer is yes. Why? It can be gleaned. If we are going to read Section 11, it can be gleaned from the amendment that somehow the third-party complaint must at least be related to the main action, because the new Section 11 provides that when matters are extraneous to the issue in the principal case, or the effect of a third-party complaint would be to introduce new and separate controversy into the action, the judge is bound to deny the same. So what can we get from it? So it tells us the idea that at least if we file a third-party complaint, it must at least be related to the main action. Otherwise, the third-party complaint will be denied by the court. Okay, but take note, if you're going to read intently Section 11, it's actually a discouragement. Discouragement on the part of the defendant to file a third-party complaint. Why? Because it will drag the resolution of the main case. Anyway, the defendant will not be prejudiced because he can always file an independent case against the supposed third-party defendant. Okay? And pertinently, the Supreme Court must have been inspired by its ruling in the case of China Banking Corporation versus Padilla, wherein the trial courts are not specifically or spatially enjoined by law to admit a third-party complaint. They are vested with discretion to allow or disallow a party to an action or to implead an additional party. Thus, a defendant has no vested right to file a third-party complaint. As I have said, there is actually no harm on the part of the defendant, considering the fact he can ventilate his claim in a different action. Okay. So with respect to Section 12, there is no amendment. 13, there is no amendment, and that's it. Okay, that is the amendments that were introduced insofar as Rule 6 is concerned. Okay, now we go to Rule 7. The amendments that were introduced to Rule 7 is actually earth-shaking on the part of the practitioners, because it is very hard to file a case now and even to file an answer. Okay, you will discover why as we go along. Okay, with respect to Section 1 of Rule 7, there is no amendment. Okay, Section 2, with respect to the body of the pleading, also there is no amendment. Now, with respect to Section 3, the signature and address. Okay, every pleading must be signed by a party or counsel representing him. Okay. Now, where lies the amendment? Take note that under the old rule, okay, what is the meaning of the signature of a lawyer on his pleading? What does a lawyer signify when he affixes his beloved signature on the pleading? Not only attorney's fees. Not only attorney's fees. That is not only the meaning of the signature of lawyer on the pleading. But under the old rule, okay, the signature of a counsel constitutes a certificate by him that, number one, he has read the pleading. Number two, that to the best of his knowledge, information, and belief, there is good ground to support it. And number three, It is not interposed for delay. That is only what lawyer certifies or attests when he affixes signature on the pleading. Now, today, as we speak, that is now different. What is the certification? What is the meaning of the signature of a lawyer, of a counsel on a pleading? It's not limited to that he has read the pleading. Okay? It is not limited to the best of his knowledge and information there is ground to support it. But it is more than that. Why do I say that? Because when a lawyer signs a pleading, he certifies that the pleading that he signed is not being presented for improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. That when a lawyer affixes his signature on a pleading, the claim defenses, he attests that the claim defenses and other contentions are warranted by existing law or jurisprudence, or by non-frivolous argument for extending, modifying, or reversing existing jurisprudence. That when you affix your signature on a pleading, the factual contentions you attest and you certifies that the factual contentions on the pleading that you have signed have evidentiary support. Or when you prepare an answer and affix your signature on the answer, you are attesting, the lawyer is attesting that the denials of the factual contentions are warranted on evidence, or if is specifically so identified, are reasonably based on belief or lack of information. So when you affix your signature on the pleading, that is not an empty ceremony under the amendment that was introduced to the 1997 Rules on Civil Procedure. In some of my lecture, especially when the audience are practitioners, one of the reaction is that, Judge, ay napakahirap naman palang mag-file ng pleading ngayon, ano? Because of the certification when we affix, okay, our signature on the pleading. Okay? Napakahirap na talaga mag-file ngayon ng mga baseless suit or ang intention lang to harass. Okay? There is, when I was in practice, okay, we are told that the best defense is offense, especially when our client obtain a loan from the bank and their loan is secured by a real estate mortgage. When they became due and demandable and our client do not have money to pay, and it will lead to the foreclosure of the real estate mortgage, what you usually do is to file an action against the bank in order to restrain the foreclosure of the real estate mortgage. We ask for TRO and injunction, and when we file that case, are we expecting to win it? Are we expecting to win that case? The answer is no. Because the only purpose of filing that case is to at least to have a leverage against the bank, to bring the bank into the negotiation table. But the plaintiff in this case is not actually expecting to win. Now, under the new rule, nakakatakot na pong mag-file ng ganong klaseng kaso. Ngayon, may mga tanong po yung ibang abogado. Paano po yan? Baka po naman sa pagperma namin sa complaint, mali naman po yung sinasabi ng aming kliyente. Tama naman talaga yon. Kasi ang mga abogado, alam naman po, lahat po tayong naandito ngayon, more than 500 participants, we are all lawyers, and we know that lawyers do not tell a lie. Diba? Hindi nagsisinungaling ang mga abogado. Ang nagsisinungaling talaga, yung mga kliyente natin. Pero tayong mga abogado, kailanman hindi tayo marunong magsinungaling. Kaya maraming nasa langit ang kagaya natin. In fact, there is one story wherein in the tomb of a lawyer, doon sa kanyang epitaph, nakalagay doon, "Here lies a lawyer, even on his death, he lies." So, yun ang tanong. Ang tanong po anong gagawin natin mga practitioner? Nakakatakot pumirma sa complaint. Paano kung yung finid na information sa atin mali? Garbage in, garbage out. So, Judge, anong may papayo mo sa amin? Kung ganun talaga, para makasigurado kayo, dun sa inyong complaint, ay hayaan nyo munang ang mag-sign. Ay ang inyong kliyente, huwag muna kayo mag-sign. O kung kayo naman i-answer, defendant, dun sa answer, hayaan munang ang defendant ang mag-sign ng kanilang answer para hindi kayo maging liable sa provision ito. But what I'm saying is that hindi naman yung para makaiwas. Ang sinasabi lang ng Korte Suprema ay kung magfa-file kayo ng asunto, be sure na kayang patunayan nyo at may basihan factually and legally yung asuntong ifa-file natin. On the other hand, if we are for the defense, kung kayo ay magfa-file ng answer, be sure that the denial that you made in the answer has factual contentions. No? Pag wala, you might be liable under this provision. May penalty po ba? Meron. Yun ang nakakatakot doon. Because, please take note, under Section 3, the lawyer may receive sanctions from the court if he or she violates the rule or reneges on his or her certification. The sanction may be extended to the law firm which jointly and severally liable for violation committed by its partner, associate, and employee. And under Section 3, the sanction may be monetary sanction. Probably the court might impose how much is the acceptance fee. That could be considered a sanction. And under Section 3, it cannot, the sanction or the monetary sanction imposed by the court cannot be passed on to the client. Okay. Now, we have some detailed observation with respect to Section 3 of Rule 7. Under the 2019 amendments, there is no specified sanction when a party filed an unsigned pleading. Because under the old, an unsigned pleading produces no effect. However, it is admitted that even an unsigned, even the absence of such sanction, okay, the unsigned pleading would still produce no effect despite the absence of such sanction under the amendments. Okay. Verification. It is related to certification. And usually, alam naman po natin, ang pleading natin, laging mayroong certification, verification, and certification against forum shopping. So basically, the general rule is that, okay, a party should be the one to sign the verification. Now, if a person is authorized by a party to sign the verification, okay, it is now a requirement that the proof of such authority must already be attached to the pleading. Okay. If the plaintiff, for example, is a corporation, okay, of course, the corporation cannot sign by itself for obvious reason. The person who would sign in behalf and for the corporation, the proof of such authority, either board resolution or secretary certificate, must be attached to the pleading. Now, when a party signs the verification, what is that he attests? Okay. What is that he certifies? When a party signs the verification, okay, he certifies that, or he attests that the allegation in the pleading are true and correct based on his or her personal knowledge or based on authentic documents. That is the same under the old rule. Okay? Now, there is an addition. Okay? Letter B, the pleading is not filed to harass, cause unnecessary delay, or needlessly increase the cost of litigation. Okay? And number 3, the factual allegations therein have evidentiary support after reasonable opportunity for discovery. So it is now our obligation to our client, to advise our client, if the intention of our client is just to file a case just to harass, no? To advise them that when they sign the pleading, okay, they must be sure that they will be able to prove their allegations. Otherwise, they might be liable under Section 4 of Rule 7. Okay. Now, the requirement that proof of affiant who verified for in behalf of a party must be attached to the pleading was introduced to address once and for all the persistent issue on whether the affiant has the authority to verify the pleading for and in behalf of a party. Okay? For those who are students of civil procedure, you would encounter lots of cases which reach the highest court of the land, which only issue actually is whether the one who signed the verification and certification portion is authorized to sign for and in behalf of a party. Now, such issue will already be obviated considering the fact kung hindi ang magsasign ay ang party at some other person, okay, authorized by a party, dapat yung proof of authority to sign the verification must already be attached to the pleading. Okay. That must have been inspired by the ruling of the Supreme Court in Costco Philippine Shipping versus Kemper Insurance, wherein the Supreme Court held that we have consistently held that certification against forum shopping must be signed by the principal parties. If for any reason the principal party cannot sign the petition, the one signing on his behalf must be duly authorized. And now the requirement is the authority of the one who signs for in behalf of the client must already be attached, to the pleading. So we go to Section 5. Okay? There is no substantial amendment with respect to Section 5. Section 5, by the way, is certification against forum shopping. There is a slight amendment, okay, which is aligned with Section 4. Kapag ang magsasign ay hindi party, only authorized party, dun sa certification portion of the pleading, dapat i-attach mo na yung proof of authority issued by a party. That is the only amendment that was introduced insofar as Section 5 is concerned. Ito po ang sinasabi kong earth-shaking, no? Earth-shaking. The content requirement of the pleading. This Section 6 contents cannot be seen from the length and breadth of the 1987 Rules on Civil Procedure. This is very new insofar as civil action is concerned. The content requirement of a pleading. Okay? Aside from the requirements in Section 2, Rule 7, the following must be stated in a pleading. And what are those? Number 1, the names of witnesses who will be presented to prove parties' claim and defenses. So, for those who are practitioners there, okay, please be reminded that you are now required, as we speak, we are now required to state the name of your witnesses who are going to be presented to prove the party's claim or defense. Not only that, okay, the summary, you are now required to state in your pleading the summary of the witnesses' intended testimony. And not only that, you have already to attach the judicial affidavit of those witnesses. Okay? Not only the names, summary of their intended testimonies, and their judicial affidavit must already be attached to your pleading. Now, what is the effect? What is the effect? If you fail to attach the judicial affidavit of your intended witness to your pleading, the effect is that, okay, the effect is that such witness cannot anymore be presented. So the general rule is that only those whose judicial affidavit are attached to the pleading can be presented as a witness. Second question, Judge, pwede po bang magdagdag pa kami ng testigo other than those whose judicial affidavit are attached to the pleading? Pwede naman. But binibigyan nyo ng masyadong discretion ang judge. Except if a party presents meritorious reason as basis for the admission of additional witnesses. What is supposed to be the meaning of meritorious reason? The rule does not define. It would depend upon the circumstances of the case. Probably, upon the filing of the complaint, your witness is abroad, or your witness, this is, I think, is the most meritorious reason, your witness is presently confined in the hospital for COVID. For sure, you can reserve that kind of witness. Okay? What else? What are the things that you have to state in your pleading? Okay? Documentary and object evidence in support of the allegations contained therein. Okay? The rule says you state, not attach. Not attach, no? Because how could you possibly attach an object evidence to your pleading? You just have to state the object evidence that you intend to present that would be used to prove the allegations in the pleading. Okay? So, earth-shaking yan. No? Kaya, ang hirap na ngayon na mag-file ng complaint. No? Pagod kayo. Dati ultimate facts lang. 3 pages complaint. Ayos na. Makakasingil na ng appearance fee. Ngayon, hindi pwede. Napakaraming gagawin bago makapag-file ng complaint. Now, what is the effect if a party fails to attach to his or her complaint or answer an affidavit of his or her witnesses? A party may not be able to present as witnesses those whose judicial affidavit were not attached to the complaint or answer, because Section 6 of Rule 7 provides very clearly, only witnesses whose judicial affidavits are attached to the pleading shall be presented by the parties during trial. Now, can a party present other witnesses in addition to those whose judicial affidavit are attached to the pleading? As I have said, yes, but you must present meritorious reason. Okay. I have some observation with respect to Section 6 of Rule 7. Section 6 does not provide for a consequence if a documentary object evidence in support of an allegation were not stated in a pleading. Can a party still present them if they failed to mention the documentary evidence or the object evidence which will be used to prove the allegation in the pleading? Okay. Now, what if the pleading failed to state everything? Failed to state the names of the witnesses, okay? Failed to state the summary of the intended testimony of those witnesses, failed to state or attach the judicial affidavit of those witnesses, or failed to state the documentary and object evidence that will be used to prove the allegations in the pleading. Can the judge dismiss the complaint motu proprio? That's the question. Okay. Because if you read Rule 7, specifically Rule 6, there is no specified sanction. Rule 6 does not say if the content requirement of the pleading is not complied with, then the court can dismiss it motu proprio. Okay. This issue cropped up in almost all of our lectures, including judges. Judges are actually talking about, we are talking it to ourselves, no? We are discussing it. What should we do if this situation happens? There is no compliance on the content requirement under Section 6 of Rule 7. Okay. I submit that. I am not saying that this is 100% correct, no? But the court may dismiss the complaint motu proprio. Okay. Judge, wala naman pong nakalagay sa Section 6 eh. Sinasabi lang sa Section 6, ito ang content requirement, no? Pero hindi sinasabi sa Section 6 na kapag hindi sumunod sa content requirement, i-dismiss ng kaso, hindi ng korte ang complaint. But of course, my basis would not be Section 6. Okay? My basis would be Section 3 of Rule 17, the most powerful provision that the court may employ. And what is that? If there is failure to prosecute for an unreasonable period of time, the court can dismiss. If there is failure to follow the order of the court can dismiss the action. The last thing, if there is failure to follow the order of the court, which includes the content requirement under Rule 7, the court may, upon motion from the adverse party or upon its own motion, can dismiss the action. So, the court may do that, no? The court may do that. So, don't wait the court to employ Section 3, Rule 17. So, for those who are practicing lawyers, the best thing to do is that when you file a complaint, be sure that everything is complete already. Because you have plenty of time to gather witnesses. So long as the period of prescription is not yet setting in, you have plenty of time. But be mindful, of course, of the rules on prescription, no? Baka sa kahahanap yun ng testigo, ay prescribe na pala ang inyong action. What I'm saying is, walang problema sa plaintiff, technically. Because the plaintiff has a plenty of time to gather everything before lodging the complaint in court. So if I am the plaintiff, kompletuhin niya. Para hindi naman, kung alam mo kasi ang, baka pag nakitang defective, baka magkalakas ang loob ng huwes. So employ natin ang Section 3, Rule 17, dispose na ang case na yon. kawawa naman ang practitioner. Kaya kung magpa-file ng kaso, it is my advice actually to complete everything, no? Based on what is required in Section 10 of Rule 7. Okay. So yon. So kaya ko nasabing earth-shaking yan, no? Ang hirap na mag-file ng complaint, pati answer ganun din. Take note that the content requirement is not only applicable to initiatory pleading, it is not only applicable, okay, it is not only applicable to complaint, but it is also applicable insofar as answer is concerned. Okay. Let us go to Rule 8. Okay. Section 9, there is a slight amendment to conform to what we have discussed, the content requirement. Look at Section 1. Every pleading shall contain in a methodical and logical form a plain and concise and direct statement of ultimate facts. So what is the addition? Including evidence, because that is required in Section 6 of Rule 7. Okay? So, we would expect, okay, when cases are filed, civil cases are filed in court, makakapal na ngayon. Kasi nung una, as I have said, tama na ang 3 pages. Bakit? Kailangan mo lang ultimate facts eh. In fact, the allegation of evidentiary facts are actually frowned upon. Ultimate facts lang, no? 3 pages na complaint, makakasingil na ng acceptance plea. Ngayon, it's not enough, no? Talagang pati ebidensya, ilalagay mo na sa inyong complaint. Ngayon, tanong ko, ito po ay bago sa civil action insofar as the 1997 Rules on Civil Procedures concerned. But this is not actually new insofar as our procedural law is concerned, because this requirement is already reflected in a different rule. That is the rule for the rules of procedure for environmental cases. Okay, because those who are practicing environmental law is familiar of this rule, because it is provided in Section 3, Rule 3, that the plaintiff shall attach to the verified complaint all evidence proving or supporting the cause of action consisting of the affidavits of the witnesses, documentary evidence if possible, object evidence. The affidavits shall be in question and in answer form, okay, and shall comply with the rules on admissibility of evidence. So everything must be attached to the pleading. That is the same requirement that we have now insofar as civil action is concerned. Section 2, there is no amendment. Section 3, Section 4, Section 5, okay? Section 6, slight amendment lang naman. Kapag ang cause of action mo ay based on decision, either ng foreign court or domestic court, the authenticated copy of the judgment or decision shall be attached to the pleading. And how do you authenticate a foreign document? Then you use the provision of the Apostille Convention. So, Section 7, no amendment. Section 8, of course, this is what I am referring to of the when we were discussing an actionable document, that if an actionable document is not specifically denied under oath, its due execution and genuineness, then it will be an implied admission of the due execution and genuineness of the actionable document, and there are defenses which are cut off by the implied admission of the due execution and genuineness of an actionable document. This includes one of which is forgery. This kind of defense is actually cut off when you were not able to deny under oath the due execution and genuineness of an actionable document. So Section 9, there is no substantial amendment. Okay. With respect to Section 10, okay, this is specific denial on how to deny a complaint. So we know already the 3 methods of how to deny allegations in the complaint. Now we move to Section 11, material averments in the pleading asserting a claim or claims. If they are not specifically denied, then they are deemed admitted. Okay. Now, dito marami ding amendment. Okay. We have to relate, okay, Section 12 of Rule 8 with Section 5B of Rule 6, affirmative defenses. Okay. Now, as what I have said, Rule 16 is already deleted from the 1997 Rules on Civil Procedure. Okay. Because all you can already, you must, in fact, okay, with some exception, okay, allege as affirmative defense those grounds for a motion to dismiss. Okay. So, Section 12. A defendant shall raise his or her affirmative defense on his or her answer, which shall not be limited to the reason set forth in Section 5B, okay, of Rule 6. You can allege the following ground as your affirmative defenses. 1, 2, 3, 4, 5, lack of jurisdiction over the defending party, improper venue, plaintiff has no capacity to sue, that the pleading asserting a claim states no cause of action, or that the condition precedent for the filing of the claim has not been complied with. Take note, ladies and gentlemen, that these are some of the grounds for motion to dismiss under the former Rule 16 of the old rule. Okay. And as I have said, you can still file a motion to dismiss, but only on 4 grounds. Lack of jurisdiction over the subject matter, litis pendentia, res judicata, and prescription. Okay? Those are the only 4 grounds by which you can file a motion to dismiss. But if you use these grounds in Section 12, that is already a prohibited motion under Rule 15. Okay? So ito hindi na pwede siyang maging ground for a motion to dismiss. Now, failure to raise the affirmative defenses at the earliest opportunity shall constitute waiver thereof. Of course, we know the exception, one of which is lack of jurisdiction over subject matter. Because when we talk of jurisdiction over the subject matter, it is a matter of law. So if it is a matter of law, it cannot be subject to waiver. It cannot be subject to agreement of the parties, except, of course, when jurisdiction by estoppel would come in accordance with the case of Tiham versus Sibong Hanoy and companion cases. Okay, and also prescription, res judicata, and also litis pendentia, they are not being waived. Now, let us suppose that the defendant interposed as affirmative defense the 5 grounds: lack of jurisdiction over the defending party, venue improperly laid, plaintiff has no legal capacity to sue, failure to state a cause of action, condition precedent has not been complied with. Supposing that is the affirmative defense of the defendant. What should the court do? The court shall motu proprio resolve the affirmative defenses within 30 calendar days from the filing of the answer. So for those who are practitioners, what can you notice? Okay? Walang nang hearing if those are the ground in your affirmative defenses. No? So nabawasan po tayo ng hearing ngayon. Di ba ordinarily, pag file ng complaint, abogado tayo ng defendant, instead of immediately filing an answer, we examine the complaint, the allegations in the complaint. If we see therein some sort of a defect, what do? We file a motion to dismiss. And of course, this is a litigious motion. We set the same for hearing. O, di makakakolekta na tayo ng appearance fee. Nabawasan ngayon ang ating appearance fee sapagkat wala ng hearing with respect to these 5 affirmative defenses because the court shall motu proprio resolve the above affirmative defenses within a period of 30 calendar days from the filing of the answer. Now, Judge, paano po kapag ang aming affirmative defense ay those which are stated in Section 5B, Section 5B of Rule 6. Ano ba yung mga affirmative defenses na yun? Okay. Those which are provided under Section 5B. Okay. Fraud, statute of limitation, release payment, illegality, statute of fraud, stoppel, form recovery, discharge, and bankruptcy. Paano po kung yon ang aming affirmative defenses? What will the court do? Okay. The section 12 is very clear. Okay. As to other affirmative defenses under the first paragraph of section 5B, okay, the court may conduct summary hearing within 15 calendar days from the filing of the answer. So, to simply put it, kapag ang ground nyo po sa inyong affirmative defense are among those grounds which are provided in section 5B, dun lang magkakaroon ng hearing because it involves factual determination from the court. Kaya may hearing. Okay? Madami bang hearing? Basta ang hearing dapat tapusin within 15 days. Calendar days from the filing of the answer. And the court shall resolve the same within a period of 30 calendar days from the termination of the summary hearing. So for those who are enterprising practitioner, para magka-hearing, agad ako ay dilalagyan ko ng affirmative defense which is provided in section 5B of Rule 6 kasi doon pwedeng mag-conduct ang court ng summary hearing. Take note, the court may conduct. The rules does not say shall conduct, but the court may conduct summary hearing. Because if on the face of the pleading, the court can actually resolve the affirmative defense of a party, whether under section 12 of Rule 8 or under section 5 of Rule 6, hindi na maghihiring ang court. Kaya nga, pinabibilis ang resolution, binabawasan masyado ang hearing. Now, okay. So we now, alam na natin kung kailan may hearing ang ating affirmative defense at kailan wala. But the mandate is for the court to resolve it within 30 calendar days as the case may be. Now the question is, Judge, paano po kapag na-deny ang aming affirmative defense? Can we file a motion for reconsideration? The answer is no. Can we subject the order denying the affirmative defense to petition for certiorari, prohibition, and mandamus? The answer is no, because that is now prohibited by section 12 of Rule 8. Okay? Affirmative defenses, if denied, shall not be subject of a motion for reconsideration. You cannot even file a petition for certiorari, prohibition, and mandamus. Question po, maganda po ba ito? I think yes, it is actually a great improvement of the old rule. Why? What is the old rule? A complaint is filed, it was served to the defendant instead of filing an answer, ano pong ginagawa ng defendant? File a motion to dismiss. If the motion to dismiss is denied, file a motion for reconsideration. Then, if it is denied, what do lawyers do? They file a petition for certiorari before the higher court. And they, in fact, they have prayer for TRO and injunction. And if they are lucky enough, they will be able to get an injunction, pero medyo mahirap na ngayon yan, then the main case will be suspended. Or they would file a motion to suspend proceedings on the ground of the most abused reason, judicial courtesy. Despite the fact that there were several rulings of the Supreme Court already disregarding such kind of rule. Okay? In fact, such kind of rule, as we go along, when we go to motions, Rule 14, prohibited motions na yun. So what I'm saying is, affirmative defense, order, denial, no motion for reconsideration, no petition for certiorari, prohibition, or mandamus. Now, the question is, what about granting? The affirmative defense is granted by the court. Okay? That is the order. Take note that if an affirmative defense is granted by the court, what is the result? It would lead to the dismissal of the case. So how are we going to categorize such kind of order? Is it an interlocutory order or a final order? It is a final order because there is nothing more for the court to do That is a final order. Now, question, can it be subject of a motion for reconsideration? It is my submission that yes, because what is prohibited by this rule is the filing of a motion for reconsideration if the order of the court with respect to affirmative defenses is denial. But if granting final order leading to the dismissal of the case, then you can file a motion for reconsideration before you can avail of the available remedy like appeal, for example. Okay. So that is the amendment that is introduced to Rule 8, Section 12. Okay. So, Section 13, walang pong masyadong amendment except the, ito po, lahat naman makikita natin, pag may nakalagay doon na days, lagi, it is supposed to mean calendar days. Okay? So, we go to Rule 9. There is not much amendment in so as Rule 9 is concerned, except the inclusion of gender-inclusive language. Okay? So, we move to Rule 10. Okay. Rule 10. Amended and supplemental pleading. Okay. So Section 1, there is no amendment. Section 2, there is a slight amendment, putting the word calendar before days. Okay. But let me first explain it before we go to Section 3. As we all know, there are two kinds of amendment to the pleading. Amendment which is a matter of right, and amendment by leave of court which is subject to the discretion of the court. Okay. When will there be amendment as a matter of right? Of course, prior to the filing of the responsive pleading. And jurisprudence will tell us that even if the defendant filed a motion to dismiss, the plaintiff can amend his complaint as a matter of right because of the principle that motion to dismiss is not a responsive pleading. That principle has not been changed. Okay. Now, if it is a matter of right, can you amend your complaint in order to confer jurisdiction to the court? Let us exemplify. Sum of money, 200,000 amount to be collected from the defendant is filed with the RTC. The court did not motu proprio dismiss the complaint. Okay? The court did not motu proprio dismiss the complaint. The defendant did not file a motion to dismiss on the ground of lack of jurisdiction over the subject matter. Ano pong ginawa ng defendant? Nag-file ng answer. Tapos sinet up niya as affirmative defense, lack of jurisdiction over the subject matter. Nakita ng plaintiff, oo nga, mali ang complaint ko, 200,000 nilagay ko. So, sabi ng abogado, amend natin lang yan, ilagay natin ang utang, 500,000. So, can the plaintiff amend his complaint as a matter of right? Even the purpose of the amendment is to correct the jurisdictional defect in his complaint. The answer is yes, because the amendment is a matter of right. It is done prior to the filing of the responsive pleading. In fact, there is one decision by the Supreme Court that the motion to dismiss is already granted, but the order dismissing the action is not yet final and executory. Ang issue doon, can the plaintiff still amend his complaint as a matter of right? The Supreme Court said yes, because it can be done prior to the filing of the responsive pleading. Okay, now we go to Section 3. Okay, we go to Section 3. This is amendment by leave of court. And when is it available? Okay? When there is already a responsive pleading. Okay. When there is already responsive pleading. Okay. Under the new rule, okay, not just like the old, there are grounds by which the court can deny the motion to amend pleading. Okay? And what are those grounds? Number one, when the motion is intended to delay. Number two, when the purpose of the amendment is to confer jurisdiction on the court. Number three, when the purpose of the amendment is to state a cause of action which is not existing at the time of the filing of the complaint. Take note that if you read the jurisprudence, the decision of the Supreme Court, this is not actually new, no? The Supreme Court just incorporated its decision in Section 3. Because there are decisions of the Supreme Court like Campos Rueda Corporation versus Bautista, Gaspar versus Dorado. That is the very same issue. The Supreme Court said complaint cannot be amended to confer jurisdiction on the court in which it was filed if the cause of action originally set forth was not within the court's jurisdiction. This is because the court must first acquire jurisdiction over the subject matter in order to act validly on the same, including its amendment. Sapagkat ang tanong nga po dun nag-file ka ng motion for leave. So the court has to act on motion for leave. But how can the court act, which has no jurisdiction, act on the motion for leave? That is the reasoning of the rule. Now, another ground to deny the motion to amend. If the purpose of amendment is to state a cause of action which is not existing at the time of the filing of the complaint. This is actually inspired by the case of Swagsman Hotel and Travel versus Court of Appeals. Let us give an example. Supposing the defendant issued 3 promissory notes with 3 different due dates. The first promissory note is due and demandable in January, the second, July, the third, December. Okay. The first promissory note became due and demandable without the defendant paying. So the plaintiff filed a complaint against the defendant. Cause of action, the first promissory note. Okay. While that case is pending, the second promissory note became due and demandable without actually the defendant paying. So what did the plaintiff do? He wants to incorporate the second promissory note. He filed a motion to amend complaint in order to state the second promissory note or to allege a cause of action based on the second promissory note. Should the court grant the motion for leave to amend? The answer is no, because the purpose of the amendment is to state a cause of action which is non-existent, which is not existing at the time of the filing of the complaint. So, if we are the plaintiff in that situation, what we are supposed to do? Don't file a motion for leave to amend complaint. You just file a motion for the filing of a supplemental pleading. Okay. All right. So Section 4, there is no amendment. Then Section 5, okay. There is a slight amendment, pero mas maganda ngayon ang Section 5 than the old rule. Why? We know, of course, we know, of course, the idea of amendment to conform to evidence. Okay, this is applicable in civil cases, but amendment to conform evidence is not applicable to criminal action in as much as it will violate the constitutional right of the accused to be informed of the nature and cause of the accusation against him. It is applicable in civil cases. And when we say amendment to conform to evidence, okay, what we are saying is that when the issues not raised by a pleading are tried with the express or implied consent of the parties, they shall be treated in all respects as if they had been raised in the pleading. Substantially, they are the same. So what is the difference? Under the old rule, if that is the case, you still have to file a motion to amend the pleading in order to conform to evidence. Under the new rule, no need to file such kind of motion. The rule says no amendment of such pleadings deemed amended is necessary to cause them to conform to evidence. Okay, so Section 6, gender inclusive language and also the calendar days. Section 7, no amendment. Section 8, they just changed the word received to offered, but substantially they are the same. Okay, and we go to Rule 11. So It's now 3:25. Mabibitin tayo dun sa Rule 11. So siguro before we go to Rule 11, let's have a break for 5 minutes. Okay, 5 minutes. We come back at what time is it? After 5 minutes. Okay, thank you.
Hello. Hi. Hope everyone is okay. Mag-snacks muna po tayo. We already received questions on our Q&A chat box. When we resume, we will ask the okay. I hope everybody is okay. When we come back after the 5-minute break, we will ask the questions we have so far received. And then we will also call those who have already raised their hand to ask the question. You may ask the questions personally. So we'll see you again online after 5 minutes break. Thank you very much.
Okay, we can now proceed. We have received several questions here, but they were too many. But I would like to ask Chris, no, kung merong mga tanong dyan. Kasi, hello?
Yes, Judge Hito. So, good afternoon to everyone. We will now open the floor to some of the questions as stated in the question and answer, and as well as in the chat box here. So, may I call on Judge Selma Alaras? I think she raised her hand for the question. Yes, Judge Alaras.
Sorry, I did not.
Okay, so let's call on Attorney Cynthia Bahamunde for your question. Yes, Attorney Cynthia, you can ask your question.
No, I have no question as of now. I don't know how the button was.
Okay, sorry.
Sorry.
Let's now go to the questions from the question and answer. First question here, as to the liability of a lawyer in signing pleadings, the question is this retroactive, since rules apply retroactively, Judge?
I think if you would ask me, I think the applicability of such rule is prospective, because you cannot punish a lawyer on something which he does not know, which is no, that principle is actually established just now. So you cannot punish a lawyer for a principle which was just established, which was happened, and the act of a lawyer happened in the past. So that is prospective insofar as the liability of lawyer is concerned.
Okay, thank you, Judge. Let's go to the next question. If a complaint is dismissed via motion of the defendant, can he still file a separate case afterwards to assert damages, which should have been a counterclaim?
Well, that is a very good question. It would depend on the nature of the motion to dismiss. For example, the motion to dismiss, usually our counterclaim is malicious prosecution, it's frivolous. That is usually a ground for our counterclaim. Now, if a complaint is dismissed via motion to dismiss, I would say that you can file a counterclaim depending on the ground why the court dismissed the case. If the ground is, for example, lack of jurisdiction over the subject matter, because as I have said, there are only 4 grounds by which one may be able to file a motion to dismiss. The first one is lack of jurisdiction over the subject matter. The second one is litis pendentia, res judicata, and prescription. If the ground, for example, of dismissing via motion to dismiss is lack of jurisdiction over the subject matter, I think you cannot file some sort of damages for a party filing a complaint in a court which does not have jurisdiction. It might be possible if you file a complaint and it was dismissed based on res judicata, because a party should know that a particular case has already been litigated, and here you are filing again a case, then it might be interpreted as a form of harassment. I think on that ground, you may actually file a case for damages on account of the filing of such kind of complaint, which was dismissed on such ground. Depending on why the motion is granted.
Thank you, Judge. There's another question here. What is the effect of the amendments to family cases or those under special rules? Will the amendments to the rules be applicable as well?
Okay. So, it is my submission that there are specific type of cases which is covered by specific type of rule. Okay? One of these is the rules on annulment of cases. Okay? If there is a specific pronouncement in this rule that it would amend such specific rule for specific cases, then it would apply. But apparently, I think there is none. So if you would ask me, then the rule with respect to annulment of cases would still apply because that rule applies for a specific type of case. This rule applies for a general type of civil action. No? So we apply a specific rule for a specific case, which includes the rules for annulment of marriage, legal separation, and that sort.
So, Judge, special rules would prevail over the general rules.
Yes, special rule will prevail.
Okay. So, Judge, we have Attorney Oscar Caraan who has raised his hand. You may now ask your question to our speaker. Okay. Okay.
Say, kung lahat ng affirmative defenses na iniraise ng defendant were denied by the judge. So technically, there is no more case anymore. So it is now mandated for the judge to decide the case already.
So,
Wala na gagawin pa.
sige, Attorney Caraan, what you're saying is that all affirmative defenses were denied by the court.
Yes.
Okay. So what you're saying is that there is nothing more to be done by the court.
Done by the judge.
By the judge. Okay. So my take is that if that is the court, the case can still the case can still proceed. Okay. The case can still proceed.
Yes, but the case should only proceed for the purpose of rendering judgment by the judge because there is no more genuine issue to be resolved by the judge. Wala nang depensa.
Okay. Let us specify the defense of the defendant because there are lots of defenses.
Yes, okay. Assuming nga judge na yung lahat ng affirmative defenses niya ay dininay na ng judge mismo. Pagkatapos there is no more available defense doon sa kanyang answer. So technically, there is no more genuine issue to be resolved or to be heard.
Now, if that is the case, then you are already admitting that the judge is already correct on his ruling. If you will not anymore proceed to trial.
I understand na you cannot appeal the denial eh.
Precisely.
Dahil ibig sabihin nun, tama yung judge.
Precisely. What we're saying is that you will proceed to trial and then assign as assignment of error the denial of the affirmative defenses. But if you will not do anything anymore, that is already an acceptance on the part of the defendant that the judge is correct. If you are not going to push with the trial of the case. Kasi marami naman kasi Attorney Caraan na issue, di ba? Ang issue hindi lang ang legal. Pwede kasing hindi amenable ang judge doon sa legal argument mo sa affirmative defenses. Pero meron ka pang issue na factual which has to be resolved by the court. And it can be resolved by presenting evidence. Kasi ang mga affirmative defenses mo, it may be legal affirmative defense or factual affirmative defense. Pag factual affirmative defense, no, summary lang naman ang hearing dyan, hindi na ventilate ang lahat, no? So it can still be ventilated in the trial proper. So pwede ka pa rin magtagumpay sa iyong kwan kahit initially yung affirmative defense mo ay denied by the court. Kasi ang problema dyan, pag wala ka nang gagawin at parang sinabi mo na sige, wala na tayong gagawin dito kasi na-deny ng affirmative defenses, then you are already, that's good for the court because you are already accepting at that point in time that the court is already correct if you will not proceed with the proceedings.
Pwede pa bang mag-proceed dun, Judge? Okay.
Okay, thank you, Attorney Caraan, for that question. Probably we'll have one last question before we proceed, and then if we have time later, we can read the other questions. Attorney Aris Liwag, do you have a question to judge? Yes, Attorney Aris.
Yes, Judge, good afternoon.
Aris, kumusta ka?
Yes, sir. Okay lang, sir. Okay lang po. Actually, dati kasi, under Rule 17, Section 6, yung hearing on affirmative defenses. Hello, can you hear me?
Yes,
Judge?
yes, we can hear you, Attorney Aris.
Okay. Okay. Let's say you said earlier that the judge must decide within 30 days motu proprio. Can this, or is this rule applicable to any pending motion to set hearing on affirmative defenses presently? Can we still,
Okay.
can we now apply this rule? That is, kasi meron akong pending motion to set hearing affirmative defense based on prescription, pending ngayon. So, can the court do away the hearing and decide the motion motu proprio?
Okay. Based on dun sa effectivity ng amendment, nakalagay doon, it is effective upon new cases that is filed and also pending civil action in court. So if that is the case, then the court may already implement the provision of the amendment with respect to the pendency of the case, no? Kasi nakalagay doon, duly filed, and those cases which are pending. So these rules may be applicable to those cases which are already pending at the time of the effectivity of this rule.
Okay, thank you. One last question. Let's say the complaint fails to attach the judicial affidavit of the witnesses. Can that be cured by amendment?
And that be cured by?
Amendment.
Okay. So that is a very good observation, but it is my take on the matter is that prior to the filing of the responsive pleading, okay, that is the best way for you to amend your complaint. So you can amend it as a matter of right. If initially you failed to attach the judicial affidavit and there is yet no service of responsive pleading, that is the best time, the last opportunity on your part, actually, should I say, for you to be able to amend your complaint and attach the necessary judicial affidavit for you not to be sanctioned later on, that your witness will not be presented, will not be allowed to be presented because his judicial affidavit was not attached to the pleading. What I am trying to say is that that is your last opportunity to actually amend your complaint, your pleading, because your pleading is actually, the amendment is actually a matter of right at that point in time.
Okay, thank you, Judge.
Thank you for
Okay.
your questions. Judge, due to time constraints, we will collate all the questions, and if you have time later, we can go back to them. So, Judge, you may now continue with your lecture.
Thank you, Chris. Okay, let us now proceed. We discuss Rule 11. Okay, this is the period of when to file a responsive pleading, the period of time to file a responsive pleading. Okay, take note that there are lots of amendments that were introduced to Rule 11. So we have Rule 1, Rule 2, Rule 3, Rule 4, Rule 5, Rule 6, Rule 7, Rule 8, and Rule 9. And I just summarized the amendment that were introduced, okay, in Rule 11. Okay, let's start. So with respect to answer to complaint, as we all know, we have 15 days within which to file an answer. Now, 30 days. Okay, 30 days. Okay. And then answer of a defendant foreign private juridical entity when summons is made on the government official designated by law to receive the same, 60 days if the defendant is a foreign corporation. Okay. Answer to amended complaint, that is 30 days if amendment is a matter of right. Now, if amendment is not a matter of right or by leave of court, then only 15 days. Okay. This rule shall apply to answer to amended counterclaim, cross-claim, third-party complaint, or complaint in intervention. Okay. Now, answer to counterclaim or cross-claim. Okay. That is 20 days. Answer to third party, fourth party, etc., 30 days. Reply under Section 10 of Rule 6, 15 days. Answer to supplemental complaint. Yes?
Judge Hiner, kindly share your screen.
I am sorry. Hindi pala
Thank
nakashare.
you.
Sorry. Okay. All right. Can you see it now?
Yes, Judge, clear.
Okay, okay. So, my apology. Alam mo, talagang especially dun sa mga judges, no? Usually, abrasive kami sa technology, but because of COVID-19, we are actually forced to embrace it, no? That's why we are now conducting mga video conferencing hearing, no? We're trying to learn the rudiments of technology kahit medyo mahirap, no? There was one instance wherein nasa 10th case na ako, promulgation of judgment, biglang nawala ang connectivity nung PAW lawyer. So, for release pa naman yung accused kasi time served. No? Niloko ko yung accused, sabi ko, ang malas mo naman. Ha? Last case ka na, nawala pa ng connection si Pao. But nevertheless, after several minutes, we were able to reconnect with the Pao lawyer. So the accused was actually released. Kaya yan. Pagpasensyahan nyo na, medyo nanganganay tayo sa teknolohiya. Okay, so that is actually the summary of Section 11. I would like to repeat. Answer to complaint 30 days after service. If the defendant is a foreign corporation, 60 days from receipt of summons. Then answer to amended complaint, 30 days if amendment is a matter of right. Or 15 days if amendment is not a matter of right. Why 30 days and why 15 days? Kasi pag dun sa a matter of right, totally talaga wala pang responsive pleading. Okay? So, ang sasagutin ng defendant, yung amended complaint, so 30 days. Whereas, if amendment is not a matter of right, naka-receive na ang plaintiff ng answer. Okay? So, ang pagsagot lang doon sa amended complaint, that is just 15 days. So, this rule shall apply to answer to amended counterclaim, cross-claim, third-party complaint, or complaint in intervention. Okay. Answer to counterclaim or cross-claim, 20 days. Answer to third-party complaint, etc., fourth-party complaint, or what have you, 30 days. Reply under Section 10, Rule 6, 15 days. Answer to supplemental complaint, 20 days from notice of the order admitting the supplemental complaint. So that is the summary of the amendment that were introduced to Rule 11. And of course, Section 11. Motion for extension of time, the favorite motion of the practitioner, motion for extension of time. Take note, okay? There is only one motion for extension of time that is allowed. That is motion for extension of time to file answer, okay? And the court may give you another 30 days to file answer. So technically, the defendant may have 30 calendar days within which to file answer to the complaint. As I have said, the motion for extension of time is only applicable to answer. It has no application at all with respect to any other pleading. When we go to litigious motion, upon receipt of the litigious motion, the opposite party has to file comment or opposition thereto within 5 days from receipt thereof. Question, can you file a motion for extension of time to file such kind of comment or opposition? The answer is no, because that is not an answer. Because ang pinapayagan lamang na motion for extension of time ay sa answer. Very clear ang section 11. Motion for extension of time to file any pleading other than answer is a prohibited and considered a mere scrap of paper. Okay. So we will not discuss bill of particulars because there are no substantial amendments that were introduced insofar as bill of particulars is concerned. Now we go to Rule 13. Marami pong amendment dito. No? Ang mga techie pwede na dito, considering the amendment that were introduced to Rule 13, the filing and service of pleadings, judgment, and other papers. So, Rule 13 is applicable for the rules which shall govern with respect to the filing of all pleadings, motions, and other court submissions. Okay. So, what is court submission? Okay. Because there are documents which is filed in court which cannot be categorized as pleading and motion. Like, for example, entry of appearance, manifestation. These are some examples of court submissions, but they cannot be categorized as pleading and motion. Okay, so at least mas maganda ang formulation ngayon ng Section 1. Okay, so Section 2 would give us the definition of filing and service. So there you are, with respect to the definition of filing, it is an act of submitting a pleading or any paper to the court. Okay. Service, on the other hand, is the act of providing a party with a copy of the pleading. So what is the amendment that were introduced? Okay. But this is the same as the old rule. If a party is represented by counsel, then the service should be through counsel, should be made to the counsel and not to the party. And jurisprudence will tell us that notice to a party who is represented by counsel is actually an invalid notice or an invalid service. Okay. What if a party is represented by several counsels? Okay. To whom shall you serve the pleading? Okay. To the lead counsel, if one is designated. What if lahat ng counsel mataas ang ere? There is no lead counsel. All of them are primus inter pares. Okay? So, to whom shall you serve the pleading? Then, the pleading shall be served to any one of the counsel for a party. That is the one that is introduced, that is the amendment that is introduced in Section 2 of Rule 13. Okay. Now, we go to Section 3. Okay. Ito, maganda ang amendment that was introduced by the Supreme Court insofar as Section 3 is concerned. Okay. So, manner of filing. So, take note that the traditional way of filing under the old rules, there are only two ways of filing a pleading or a motion. Okay? Number one, personal filing. Number two, filing through registered mail. That is the traditional manner of filing. Now they have expanded the scope and ways and manner of filing. Okay? Aside from the two, the traditional way, no, they have added sending them by accredited courier. So accredited courier cannot be used to file a pleading or to file a motion. Okay? An example of a accredited courier, for example, is LBC. Okay? Not only that, electronic filing is now allowed. Transmitting them by electronic mail or other electronic means as may be authorized by the court in places where the court is electronically equipped. So they have expanded the manner of filing. Instead of two, we have now 4 ways how to file a pleading. Okay. Now, when is a pleading considered filed? Of course, dun sa unang manner, submitting it to the court, it is filed on the date it is submitted to the court. Very obvious. Okay. What about the second and third cases? Filing through registered mail and through accredited courier. In the second and third cases, the date of the filing of the motion, pleadings and other court submissions, and payment or deposits as shown by the post office stamp on the envelope or registry. That is the on the date of mailing. That is actually the date of filing. Now, how about the fourth case? Electronic filing. In the fourth case, the rule says the date of electronic transmission shall be considered the date of filing. All right. So, Section 4, there is no amendment. Okay. Modes of service. Okay. So, dun sa Section 3, we tackled manner of filing. Ito naman modes of service. So, pleading, motions, notices, orders, and other court submissions shall be served personally. Okay. Shall be served personally or by registered mail or accredited courier, facsimile transmission, and other electronic means as may be authorized by the court as provided for in international conventions in which the Philippines is a party. Okay. So I just received a text message here because I understand there are lots of questions, no? So after the end of the lecture, we can accommodate, if there is enough time, we will accommodate your questions. And for those questions that will not be answered, then we will try to find means on how to address the questions that you have provided. But we can, you know, we can extend. If you want to clarify something on the amendments, then we can extend in order to address your question. So let us proceed. With respect to the modes of service, as I have said, marami ng methods of service ngayon, no? Personal service, registered mail, by accredited courier, by electronic mail, facsimile transmission, kung meron pa mang fax, other electronic means as may be authorized by the court, okay? And service or as provided for in international convention to which the Philippines is a party, one of which is the 1965 Convention on the Service Abroad of Judicial and Extrajudicial Documents in Civil and Commercial Matters. Okay. With respect to personal service, I think there is no substantial amendment with respect to it. You just have to read Section 6 of Rule 13. Then we move to Section 7, no substantial amendment. Substituted service, the same thing. And we go to service by electronic means or facsimile transmission. Okay. It has no counterpart under the old rules. It's very new. Okay. It is a mode of service, actually. Okay. Service by electronic means and facsimile. Now, please take note. This manner of service is applicable only, this manner of service is applicable only when a party concerned consents to such kind of modes of service. Okay? Pag ayaw ng party to be served through electronic means or through facsimile, then we could not impose it upon that party. They have the option, no? So, most likely, mai-imagine mo na. If a party, for example, is 80 years old, I am sure he would not allow, he would not consent to such kind of service. But if a party, for example, is 30 years old or some sort of millennials, techie, then he might allow the service through electronic means. Now, if a party consents to such mode of service, how is it done? Okay? So service by electronic means shall be made by sending an email to the parties or counsel's electronic mail address or through other electronic means of transmission as the parties may agree or upon the direction of the court. So email, you can be served through email. Okay? You can be served through messenger if the parties agree, or Viber, okay, if the parties agree, because it is one form of electronic transmission. Or service by facsimile shall be made by sending a facsimile copy to the parties or counsels given facsimile number, kung meron pa mang fax machine. All right. So we go to section 9. This is very important. Presumptive service. Okay, presumptive service. So when we were in practice, especially in civil action, and the stage of proceeding is pre-trial. Let us say we are counsel for defendant, and then we appear, our client is there. The first thing that we should determine is the presence of the other party, the presence of the plaintiff. What is our intention? Our intention is that if the plaintiff is not around, as well as his counsel, we will move for the dismissal of the complaint. That is our intention. So what do? We check the record, and we even ask the court personnel. Our question is the plaintiff notified? Tapos titingnan ng expediente, walang proof of service. Okay. So we could not move for the dismissal of the complaint, considering the fact that there is no proof of service. So what would the court do? Under that situation, the court would cancel the pretrial because of lack of proof of notice to the other party. Okay. Now, with this presumptive service, such thing might be obviated already. So what is presumptive service? There shall be presumptive notice to a party of a court, setting if such notice appears on the record to have been mailed at least 20 calendar days prior to the scheduled date of hearing, and if the addressee is from within the same judicial region of the court where the case is pending, at least 30 calendar days if the addressee is outside judicial region. So what can we have from here? Okay, the party can already presume, the court can already presume that the other party to whom the notice is given, okay, is presumed to have received the same if the notice is mailed at least 20 calendar days prior to the scheduled date of hearing. Now, if the addressee is from within a different region, then you can presume that the notice is served already by a party if it appears from the record that the notice is mailed at least 30 calendar days if the addressee, as I have said, is from outside judicial region. If that is the case, you need not have proof of service on the part of the other party. So if the plaintiff is absent and it appears from the record that the notice of pretrial was sent not at least 20 calendar days prior to the scheduled date of the hearing, then you can move accordingly. You can move for the dismissal of the complaint on the ground of absence of the plaintiff. Okay, that's very new. Section 10, Rule 10, presumptive service. Okay, so there is no more priorities in the service in filing that was deleted. Okay, change of electronic address or facsimile number. So let's make it, let's simplify it. O, pag nagpalit ka ng fax number at nagpalit ka ng email, you inform the court in the other party. Okay? Just like if you change your address, you have to inform the court as well as the other party within 5 days from such change. Because if you will not inform the court or the other party, then notices to your previous email address would still be a valid notice. Okay? With respect to section 12, this is the form. No? When you consent to electronic manner of service, then this is the form. What are you going to write on the email that you are going to send? You just read section 12. Okay. 13. Okay. 13. We are talking here of judgment of the court or final orders of the court or resolutions of the court. Now the question is, how are we going to serve them? Okay. Insofar as judgment, final orders, and resolution, we follow the traditional, the court will follow the traditional mode of service. Now, what is the traditional mode of service? Personal service or registered mail. Okay. Now, can there be other form of service with respect to judgment of the court, final orders, or resolutions of the court? Yes, it can be served through accredited courier. But of course, it will be at the expense of the party requesting for such kind of service. Kasi wag yun namang pagka ganyan yan, of course, ang magbabayad naman, hindi naman ang clerk of court. Hindi naman ang process server, obviously, ang magbabayad kung accredited courier ang service. Si judge ang magbabayad niyan. Eh kung napakaraming decision ni judge, no? At ang manner of service ay accredited courier, nakakaawa naman si judge niyan. Okay, so ang most, kung gusto ng party, accredited courier ang service at mapabilis, eh bayaran mo kung magkano ang service noon. Okay, so that's basically section 13. All right, conventional service or filing of orders, pleadings, and other documents. Okay, so simple lang po ito. There are pleadings, documents, orders of the court which have to follow the traditional way of service. That is by registered mail or personal service. And these are those, no? Initiatory pleadings, including initial responsive pleadings like answer, for example, subpoena protection orders, appendices and exhibits to motions and other documents that are not readily amenable to electronic scanning, may, at the option of a party filing, be filed and served conventionally and sealed and confidential documents or records. Okay. So we go to 15. Okay. When is service considered complete? Okay. The old rule with respect to the traditional way of service, walang pagbabago. Doon tayo sa service by accredited courier. When is it considered complete? It is considered complete upon actual receipt by the addressee and after at least 2 attempts to deliver the same, to deliver by the courier service, or upon the expiration of 5 calendar days after the first attempt to deliver, whichever is earlier. With respect to electronic service, it is complete at the time of electronic transmission of the document, or when available at the time that the electronic notification of service of the document is sent. Electronic service is not effective or complete if the party serving the document learns that it did not reach the addressee or persons to be served. By facsimile transmission, it is complete upon receipt by the other party as indicated in the facsimile transmission printout. And we are familiar with this. Okay, so proof of filing. If the pleading is by court submission, of course, the idea of proof of filing is actually, there is no actually substantial change between the old and the new with respect to the proof of filing. I suggest that insofar as personal filing is concerned or through registered mail, the principle is still the same. But if a pleading or any other court submission was filed through accredited courier service, the filing shall be proven by an affidavit of service of the person who brought the pleading or other document to the service provider, together with the courier's official receipt and document tracking number. On the other hand, if the pleading or any other court submission was filed by electronic mail, the same shall be proven by affidavit of electronic filing of the filing party, accompanied by a paper copy of the pleading or other document transmitted, or a written or stamped acknowledgement of its filing by the clerk of the court. If the paper copy sent to electronic mail was filed by registered mail, then paragraph B of this section applies. Now, if the pleading or any other court submission was filed through authorized electronic means, then the same shall be proven by affidavit of electronic filing of the filing party, accompanied by a copy of electronic acknowledgement of its filing by the court. Okay. So proof of service, except with respect to ordinary mail and registered mail, the same as the old, no? Ano ang proof of service naman kapag accredited courier ang service? Proof of service shall be made by an affidavit of service executed by a person who brought the pleading or paper to the service provided together with the courier's official receipt or document or tracking number. Pag electronic mail naman or facsimile or other authorized electronic means of transmission, proof shall be made. Proof of service shall be made by an affidavit of service executed by the person who sent the email, facsimile and other electronic transmission, together with the printed proof of transmittal. Okay. So, this one, Section 18. Okay. We will relate it to Section 13. Section 13 is document coming from the court. The same is true with Section 18. The difference is that when we speak of Section 13, okay, we are referring to final judgment of the court, decisions, or final resolutions of the court. Ito, yung mga interlocutory orders. Sabi natin kanina sa Section 13, pag final judgment, decision, we follow the traditional manner of service. Okay? Unless, by ex parte motion, the other party wishes to be served through accredited courier. But with respect to other orders of the court may electronically serve orders and other documents to all parties in the case which shall have the same effect and validity as provided herein. Paper copy of the order and other document electronically served shall be retained and attached to the record of the case. That is applicable when, of course, a party consented to such kind of service, electronic mode of service. Okay. So 19, there is no substantial amendment except the inclusion of gender-inclusive language and now summons. Okay. There are many amendments introduced insofar as summons is concerned, but by way of analysis, medyo sa tingin ko, no, naging liberal. Liberal ngayon ang approach with respect to the service of summons, specifically if the defendant is a domestic juridical entity. Kasi under the old rules, sobrang hirap mag-serve ng summons if the defendant is a corporation. Now, they have relaxed the rule. Okay, and we will see that later on. Okay, so Section 1, okay, unless a complaint is on its face dismissible under Section 1, Rule 9, the court shall, within 5 calendar days from receipt of the initiatory pleading and proof of payment and the requisite legal fees, direct the clerk of court to forthwith issue some. So, what can be deduced from Section 1 is that, okay, the court can motu proprio dismiss the plaintiff's complaint. Okay? If on its face, it is dismissible under Section 1, Rule 9. And what are those grounds? If it appears from the complaint that the court has no jurisdiction over subject matter, or it appears from the complaint that the action has already prescribed, or there is litis pendentia or res judicata, the court can motu proprio dismiss the complaint. Otherwise, the court will issue summons within 5 days from the receipt of the initiatory pleading. Okay. So, Section 2, contents of summons. Section 2 should be read with Section 3. Okay. What can we take from Section 2? Okay. It can be deduced from Section 2 that it is not only the sheriff or the deputy sheriff or any court personnel who can serve summons upon the defendant. Because based on Section 2, even the plaintiff, upon his or her ex parte motion, may be allowed to serve summons to the defendant. Okay. Because it is stated in Section 2 that if the plaintiff is allowed to serve summons upon the defendant, it must be stated in the summon. Okay. Now, how about Section 3? Section 3 will tell us the persons, okay, the persons who are authorized to serve summons. Number 1, sheriff. Number 2, deputy sheriff. And number 3, other proper court officer. Now, how about the plaintiff? Can the plaintiff serve summons upon the defendant? The rule says, in case of failure of service of summons by them, the court may authorize the plaintiff to serve the summons together with the sheriff. So the service of summons must be, the plaintiff, if that is the case, must be accompanied by the sheriff. Other instance by which the plaintiff may be allowed to serve summons upon the defendant. When the defendant is residing outside the judicial region of the court where the case is pending. Because the rule says, in case where summons is to be served outside the judicial region of the court where the case is pending, the plaintiff shall be authorized to cause the service of summons. Okay. Now, if the plaintiff is a juridical entity, it shall notify the court in writing and the name of its authorized representative therein, attaching a board resolution or secretary certificate, is stating that such representative is duly authorized to serve the summons on behalf of the plaintiff. Okay. Now, what if the plaintiff misrepresented that summons were already served upon the defendant, but in truth and in fact, it was not served upon the defendant? What is the effect? If it is later on proved that no summons was served, the case shall be dismissed with prejudice, the proceeding shall be nullified, and the plaintiff shall be meted appropriate sanctions. Okay. This amendment is very good considering among anybody else, it is the plaintiff who is very much interested with the prosecution of the case. And the plaintiff usually knows the whereabouts of the defendant. That's why they made it a point in the amendment to include plaintiff, or the plaintiff may be authorized to serve summons upon the defendant. Okay. Now, if summons is returned without being served on any or all of defendants, okay, the court shall order the plaintiff to cause the service of summons by other means available under these rules. It's either by substituted service or by summons by publication, and failure on the part of the plaintiff to follow the order of the court shall cause the dismissal of the initiatory pleading without prejudice. Okay. Now, validity of summons. Okay. Just have to read it. Okay. Now we go to section 5. Okay. Section 5. Whenever practicable, the summons shall be served by handing a copy thereof to the defendant in person and informing the defendant that he or she is being served. Okay. It's not enough that the server hands the summons and complaint to the defendant. You must inform the defendant that the defendant is being served. Okay. Can you serve the summon outside the address indicated in the complaint? Outside the address of the defendant indicated in the complaint. I repeat, can you serve the summons outside the address of the defendant indicated in the complaint? The answer is yes, because the rule says summons is served by handing a copy thereof to the defendant. So if the server or the sheriff found the defendant playing golf, he can serve summons upon such defendant is playing golf. Okay, by handing it a copy thereof and informing such defendant it is being served. Okay. That is the amendment that is introduced. Okay, substituted service. Okay. Nung una po, napakadaming kaso concerning the validity of the service of summons upon the defendant. Ngayon, kinlarify na po ng Supreme Court yan. Kailan tayo mag-i-effect ng substituted service? Napakaraming mga kaso na invalidate ang service of summons considering it does not comply with the rules. No? But under the old rule, ang nakalagay lang, if for justifiable causes. Ano yung justifiable causes na yun? The defendant cannot be served within reasonable time. What is reasonable time then? Provided in the preceding section. So what seems to be the justifiable causes? And what is supposed to be the meaning of reasonable time? Would it be 6 months? Would it be 3 months? 1 month? Na-clarify na ngayon yan under the amendment. Based, of course, on the decision of the Supreme Court. Okay. Look at section 6. If for justifiable causes, okay, the defendant cannot be served personally after at least 3 attempts on 2 separate dates. So it is necessary that there must first be 3 attempts, which should be done on a separate day. Before we can say that there is failure of service, okay, prompting the application of substituted service. If there is only 1 attempt on 2 separate days, okay, or 3 attempts on 1 day, then substituted service is ineffective. Okay? The rule now is very clear. Take note that it is actually a product of jurisprudence because there is a decision of the Supreme Court which mandates that before substituted service can be effected, there must be 3 attempts on 2 separate dates, and that is the ruling of the Supreme Court in Manotoc versus Court of Appeals. Okay. So, we already know how substituted is effected. Okay. If for unjustifiable causes, the defendant cannot be served personally after at least 3 attempts on 2 separate days. Now, how is it done? How is substituted service effected? Number 1, by leaving copies of the summons at defendant's residence to the person at least 18 years of age of sufficient discretion residing therein. Okay. Now, take note that under the old rule, it is effected by leaving copies of the summons at defendant's residence with some person of suitable age. The old rule did not actually define what is supposed to be the meaning of suitable age. Now it is very clear. Huh? At least 18 years of age and of sufficient discretion residing therein. The second manner of substituted service. By leaving copies of the summons at defendant's office or regular place of business with some competent person in charge thereof. Okay. The same is with the old rule. But the beauty of the new rule is that the new rule defined who is a competent person. That a competent person includes but not limited to one who customarily receives correspondence for the defendant. And the third manner of substituted service. By leaving copies of the summons, if refused entry upon making his or her authority and purpose known with any of the officers of the Homeowners Association or Condominium Corporation or its chief security in charge of community or building where the defendant may be found. I think the Supreme Court was inspired by the ruling of its ruling in the case of Robinson's Land versus Miralles. Okay. So Robinson's Land filed a case against Mr. Miralles. Mr. Miralles is a resident of Ayala, Alabang. So when the sheriff was serving summons, of course, he has to pass through the gate of Ayala, Alabang. Sobrang hirap pumasok doon. He manifests his intention. I am the sheriff of Quezon City. I would like to go to the residence, to the house of Mr. Miralles because I am going to serve summons. Okay. Ang ginawa ng guard, tinawagan si Mr. Miralles sa kanyang bahay. Ang sabi ni Mr. Miralles, wag mong papasukin yan. Sabi ni guard, sabi ni Mr. Miralles, wag ka raw papasukin. Eh sabi ng sheriff, hindi pwedeng hindi mo ako papapasukin. Okay? Sheriff ako. Anong sabi ng guard? Sheriff ka lang, guard ako. So, sabi, hindi nakapasok si sheriff. Ano ginawa ni sheriff? Iniwan ang summons at saka complaint sa guard at sinabing, o ikaw nang makabot yan kay Mr. Miralles. Then he prepared a return, okay, reflecting what transpired when he was serving summons. Anong issue ngayon? Whether the court acquired jurisdiction over the person of the defendant, whether there is an invalid service of summons or valid service of summons. Sabi ng Supreme Court, there is a valid service of summons. Why? When the defendant, intentionally prevented the service of summons, okay, it is considered served. Siguro, para ma-obviate yung ganong situation, inilagay ng Supreme Court dito sa rule. Kapag nakatira sa subdivision, most likely, hindi makakapasok yan. Kasi tatawagan muna yan. No? So, pwedeng sa chief security, pwedeng sa president ng Homeowners Association, or the officer of a condominium corporation. And the third manner is by sending an electronic mail to the defendant's electronic mail address if allowed by the court. As I have said, all the things that are reflected in Section 6 of Rule 14 are actually products of jurisprudence, like Manotoc versus Court of Appeals, okay, the case of Robinson versus Miralles. Now, let's go to Section 7. Okay. There is no amendment insofar as Section 7 is concerned, except the word brought was changed into filed. Okay. How about Section 8? Simple lang ang amendment sa Section 8 pag ang defendant ay a prisoner, ang jail warden will be deputized as the sheriff to serve summons upon the prisoner, and the jail warden will be the one to file the return. Okay. Now, how about this? Section 9, this is actually new provision. Service may be made through methods which are consistent with established international conventions to which a party is a part. The Philippines is a party. One example of which is the 1965 Convention on service abroad of judicial and extrajudicial documents in civil or commercial matters. Okay. Section 10, no substantial amendment. Section 11, when spouses are sued jointly, despite the fact that they are sued jointly, service of someone should be made individually. Okay. Eto. Section 12, malaki po ang pagbabago insofar as Section 12 is concerned. Okay. So, for all those who are professors of remedial law, no, especially civil procedure, we always require our students to memorize these 6 corporate officers. Okay? Memorize. Why? Because the jurisprudence prevailing at that time is that these persons are the only one authorized to receive summons for and in behalf of the corporation. Okay? That service other than the 6 would be considered invalid service, and the court would not acquire jurisdiction over the person defendant. So they are exclusive. Yung mga guard hindi nakasama dyan. Okay? Yung mga secretary hindi nakasama dyan. No? Because they are exclusive. They are the president, who are those persons? The president, managing partner, general manager, corporate secretary, treasurer, or in-house counsel. Okay. Now, under the old rule, ito yung pinasok na amendment. Okay. In case of the unavailability of those absence or unavailability of those persons, the 6 persons, okay? Service of summons the summons can be served upon their respective secretaries. Sure naman tayo, yung president, managing partner, general partner, corporate secretary, treasurer, in-house counsel, may secretary yan. So in the absence of them or unavailability of them, to their respective secretaries. Now, usually naman, yan ang mga boss, di ba? Ang boss may secretary. Okay. Ang secretary laging kasama ni boss. Secretary, kung saan man pumunta, laging kasama si boss. Kaya pinagsisilosan siguro. Laging kasama. So, saan mo isi-serve ang summons? Kasi si secretary kasama ni boss. Okay? If such service cannot be made upon any of the foregoing persons, the 6 and their respective secretaries, no, it shall be made upon the person who customarily receives correspondence for the defendant at its principal office. Okay? So, in case the domestic juridical entity is under receivership or liquidation, sa receiver or liquidator. Okay. Now, ayaw tanggapin ng mga taong above mentioned. Okay? Ayaw tanggapin ng 6 corporate officers, their respective secretaries, or the persons who customarily receive correspondence to the corporation, and also the receiver and the liquidator. They don't want to accept. What is now the remedy? If there is refusal on the part of the person above mentioned to receive, despite at least 3 attempts on 2 separate dates, then service of summons may be made electronically if allowed by the court as provided under Section 6 of this rule. Okay. I remember one case, the case of Carlson's. No? The case of Carlson's Management Corporation. Because there is there is some sort of confusion on whether substituted service may be affected in case the defendant is a corporation. Kasi exclusive nga yung 6. This Carlson's Management Corporation versus Red Robin, the Supreme Court impliedly accepted substituted service despite the fact that the defendant is a corporation. But there was no an in-point ruling with respect to that. But my observation is that what is being implied in the case of Carlson's Realty Management Corporation is now expressed under the amendment. Now, under the amendment, we can say that substituted service can be affected even if the defendant is a corporation. But there is only one manner of substituted service. That is through, should there be refusal of service, then service may be made electronically if allowed by the court. Okay. So this one, section 13. Where summons is improperly served and a lawyer makes special appearance on the part of the defendant, in behalf of the defendant, among others to question the validity of summons, the counsel may be deputized by the court to serve summons on the client. Let us take this situation. A complaint is filed against the defendant with prayer for TRO and injunction. And as you all know, if an initiatory pleading is coupled with a prayer for TRO and injunction, it will be subjected to a special raffle, and the defendant will already be notified of the raffle. Okay, so summons will be served upon the defendant. Okay, if there is an ancillary prayer for TRO and injunction. Okay, let us assume that during the hearing of TRO, okay, the lawyer of the defendant appeared. And one of his grounds to oppose the issuance of TRO or injunction is the fact that the court did not acquire jurisdiction over the person of the defendant. Why? Because of improper service of summons. So anong gagawin ng court? Sasabihin ng court, so ang ground mo ay improper service of summons. Yes, Your Honor. So the court did not acquire jurisdiction over the person of the defendant, considering the fact that there is an improper service of summons. That is my point, Your Honor. If that is the case, then you are hereby deputized to serve summons upon your client. Okay. So, ang hirap i-invoke ng ground na yon. Kasi ang gagawin lang sa'yo ng korte, so since you are questioning the invalidity of service of summons, lawyer, you are hereby deputized to serve summons on behalf to your client. Okay. So that is section 13. Section 14 pertains to a situation wherein the defendant is a foreign juridical entity. Okay. This is a foreign corporation, either doing business in the Philippines or not doing business in the Philippines. So with respect to the service of summons, if that kind of corporation is the defendant, is governed by section 14. So when the defendant is a foreign private juridical entity which has transacted or is doing business in the Philippines as defined by law, service may be made on its resident agent designated in accordance with law for that purpose, or if there be no such agent, on the government official designated by law to that effect, or any of its officers, agents, director, trustees within the Philippines. And that is why, if the defendant is a foreign corporation licensed to do business here in the Philippines, paano natin malalaman kung sino ang taong authorized to receive summons? What we're going to do? Just go to the Securities and Exchange Commission, and the SEC will give us information. Okay, SEC will give us information on the person who is authorized to receive summons for in behalf of such foreign corporation doing business in the Philippines. Because before they can be licensed to do business in the Philippines, they have to submit a name and submit it to the Securities and Exchange Commission as mandated by the corporation code. Okay. If a foreign private juridical entity is not registered in the Philippines or has no resident agent, but has transacted or is doing business in it as defined by law, such service may, with leave of court, be effected outside the Philippines through any of the following means. And the rule enumerated the ways by which service of summons can be effected in that situation. So by personal service, through the appropriate court in a foreign country with assistance of the Department of Foreign Affairs, by publication once in the newspaper of general circulation in the country where the defendant may be found, by facsimile, electronic means, prescribed with the prescribed proof of service, and such other means as may be directed by the court. Okay. So with respect to section 15, no amendment. 16, they just included a period within which to serve summons upon the defendant whose whereabouts are unknown. Okay. We are taught in our civil procedure that there are several types of action. Okay? Action in personam, action in rem, and action quasi in rem. And we are taught by jurisprudence that the court will not be able to acquire jurisdiction through summons by publication in an action in personam. It is only in action in rem and quasi in rem may service by publication be effected. This is an exception to such rule. Okay? This is an exception to such rule, meaning the court may be able to acquire jurisdiction over the personal defendant even in an action in personam, and even if the way of summons is through summons by publication. Why? Look at the language of section 16. Okay? In any action, okay? In any action, it does not distinguish whether it is an action in personam, action in rem, or quasi in rem. If the whereabouts of the defendant cannot be known, then you can resort to summons by publication. Even if it is an action in personam, the court would be able to acquire jurisdiction over the person of the defendant. Okay. With respect to section 17, extraterritorial service, the same, okay, except may counting amendment as provided by international convention to which the Philippines is a party. We have discussed that already. Section 18, no amendment. 19, return. Okay. So, who may be considered server? The sheriff, deputy sheriff, or any other court officer. Okay. Plaintiff may be considered server if it is authorized by the court. So, section 20 will tell us the period of time within which the summons shall be effected. That is within, shall be served, I mean. That is within 30 calendar days, okay? 30 calendar days from the issuance of summons by the clerk of court, okay? And the receipt thereof by the sheriff. Within 30 days, okay? At pag na-serve na yon, dapat magawa ng return. Sino ang magagawa ng return? Kung sino ang nag-serve. Si sheriff ba? Hindi sinabi ng section 20. Ang sinabi ng section 20, ang gagawa ng return ay the server. The server shall file with the court and serve a copy of the return to plaintiff's counsel. So kung sinong nag-serve, siya ang magagawa ng return. Kung ang nag-serve si sheriff, ang tawag doon, sheriff's return. Eh paano judge kung si plaintiff ang nag-serve? Eh di tawagin natin siya plaintiff's return. But what I'm trying to say here is that the one who served summons upon the defendant should be and obligated to file the return. Okay. In case of substituted service, what should be included in the return? What should be stated in the return in case of substituted service? Okay. Number one, the impossibility of prompt personal service within a period of 30 calendar days from the issue and receipt of summons. Okay. Number two, the date and time of 3 attempts on at least 3 and at least 2 separate dates to cause personal service in the details of the inquiries made to locate the defendant residing thereat. Okay? And the name of the person at least 18 years of age and of sufficient discretion residing thereat, and the name of the competent person. So what we are saying here now is that it is now very easy to prepare a return because you are already guided. The sheriff or the server is already guided on what to state in the return, which is provided in section 20. Okay. So what is incorporated in section 20 is actually a product of the ruling of the Supreme Court in the case of Oca Cabrera Fallier, the case of Manotoc versus Court of Appeals. In the case of Manotoc versus Court of Appeals. So section 21, we'll just leave it at that. We move to this one. I think, and I would like to say that this is one of the most controversial provision in the amendment. Okay. Now, let us first discuss the old rule. Okay. We are told that the court will be able to acquire jurisdiction over the person, the defendant, in two manners. The first one is valid service of summons, and the second one is voluntary appearance. And of course, we know the definition of voluntary appearance. When we ask an affirmative relief from the court, that is considered voluntary appearance. When we ask something from the court, that is voluntary appearance. When we file a motion to dismiss, we are asking something from the court, then that is voluntary appearance. The court has already acquired jurisdiction over our person. Now, it is provided under the old rule that the inclusion in the motion to dismiss of other grounds, aside from lack of jurisdiction over the person of the defendant, shall not be deemed a voluntary appearance. So, if you allege in your motion to dismiss all the grounds in a motion to dismiss under the then section 1 of Rule 16 question, okay, did you submit yourself to the jurisdiction of the court? The answer is no. Because section 20 of the old rule is very clear. The inclusion in the motion to dismiss of other grounds aside from lack of jurisdiction over the person of the defendant shall not be deemed voluntary appearance. Now, the rule is 360-degree different. Why? The inclusion in the motion to dismiss of other grounds aside from lack of jurisdiction over the person of the defendant shall be deemed a voluntary appearance. Okay, look at the changes. But the problem is, if the ground is lack of jurisdiction over the person of the defendant, you are not anymore allowed to file a motion to dismiss. Diba? Kagaya po nung nasabi ko kanina, this should be set up as affirmative defense. Because there are only 4 grounds by which the defendant may be able to file a motion to dismiss, as we have been emphasizing before. Lack of jurisdiction over the subject matter, litis pendentia, res judicata, and prescription. With respect to other grounds for motion to dismiss, set them up as affirmative defense. So, where are we going now to apply section 23? When it says, the inclusion in the motion to dismiss of other grounds aside from lack of jurisdiction over the person of the defendant shall be deemed voluntary appearance. Where are we going to apply this? In the first place, we are not allowed to file a motion to dismiss on that ground. On the other hand, if we file an answer setting one affirmative defense, lack of jurisdiction over the person of the defendant, okay, can we now consider, is it not a fact that when we file an answer, we have already submitted to the jurisdiction of the court? So my question now is, when are we going to apply this particular provision in as much as lack of jurisdiction, okay, over the person of the defendant cannot anymore be set up as ground for motion to dismiss? This, I think, will be clarified by the Supreme Court when a live case is actually, when this provision is actually applied in a live case, and we will be able to know how is section 23, how are we going to apply section 23 of the amendment. Okay, so that's it. Let's go to motions. Okay, there are lots of changes also, okay, introduced with respect to motions. But before we go farther, no, we can, if Chris is around, no, we can entertain several questions if you have some list of questions there, no, before we proceed discussing rule 15.
Yes, Judge, no, we have some questions here.
Yeah,
So, first question, Judge, no, prior to the new rules, objections to the judicial affidavit of the party must be made before the presentation of the witness. So how will this apply to the present rules when they are now attached, no, to the complaint and to the answer respectively?
Okay, the same rule will apply. You will object to the judicial affidavit rule at the time you present the witness. Okay, so you need not, what I'm trying to say is that it is not yet time for the defendant to object on the judicial affidavit of the witnesses in his answer. You object it on a proper time. So when it's the proper time, when the witness is already presented, okay? Because as we all know, the judicial affidavit of the witness will constitute as the direct examination. And if there are objectionable questions on the judicial affidavit, you object it at the time that the witness is to be presented as. When the witness is to be presented to testify.
Yes, thank you, Judge. No, so next question. Assuming that you have a witness, but you are not sure if he will be available, just to be sure, is it safe to list the name of that witness in the complaint or in the pleading?
Okay. That is the safest thing to do. Okay. All conceivable witnesses that could fortify your case. No, if I am on the side of a party, I would already prepare the judicial affidavit. There's no harm in doing it. Anyway, nasa open naman yun kung ipipresent mo o hindi. Pag hindi mo pinesent, it will not be considered by the court. Ang problema, kapag hindi mo ilalagay lahat ang iyong judicial affidavit doon, no? Okay? Baka ma-waive yun, no? Kasi you must present to the court meritorious reason in order to present additional witnesses. It's better, kahit kung hindi mo man gagamitin later on o gagamitin mo, yung any conceivable witness that would prove your claim or defense should already be attached to the complaint.
Okay, Judge, thank you. Now, there's another question here. No, can a judge, instead of dismissing the complaint for not complying with the requirements, order an amendment to the pleading?
Okay. The judge would actually not do that, no? It's a call of a party. Because, you know, the tendency of a judge in that case, no? Pwede mo na kasing i-dismiss yun for non-comply with the content requirement using Section 3, Rule 17. So why would the judge help the other party? No? It might be interpreted that the judge is helping the other party. But I like the question earlier, ano? Kung pwede mo pa bang i-amend ang complaint, may nakalimutan kang judicial affidavit. Okay. So long as the responsive pleading has not been served, then you can still amend. You can still amend your complaint.
So, follow-up question to that, Judge, no? How do we treat newly discovered evidence if it was not part of the original pleading?
Okay, that can be used as meritorious reason for the presentation of additional witnesses or for the presentation of additional documentary or object evidence. You can use that as meritorious reason why you were not able to state that in your pleading.
Okay. Next question, Judge. No, the case was filed before effectivity of the new rules, and there is no answer yet. Will the court require the plaintiff to amend the complaint to comply with the new rules?
If I were in that place, I might do that. I might do that. No, considering the fact that the applicability of the amendment is it is applicable with respect to the pending cases. But this is not. This is actually my advice to practitioner. No, if you have filed your complaint already, okay, And prior to the service of answer, hindi pa naman nagbibistahan ngayon ng civil cases, this is the best time, no? For you to be able to amend your complaint, no? And contact the possible witnesses that you can present during trial. Pwede pa rin i-amend. Should I call the attention? I might. Pwede rin naman. No? I might call the attention of the parties to comply with the content requirement of Section 6, in as much as the rule is now already effective.
Thank you, Judge. Now, there's another question. Do we have a list of Supreme Court accredited private couriers now?
Okay. So, malimit itanong yan, yung question na yan, no? Kasi parang ini-equate sa bonding company, no? Before a bonding company may be allowed to post bail in behalf and for of the accused, dapat accredited siya, no? Pero I think when we speak of accredited courier, ito yung existing accredited courier. Yung accreditation doon, it's not actually accreditation before the Supreme Court, but the existing courier like LBC, like JRS, kasi may tracking devices sila eh, no? Hindi mo pwedeng tanggi kung hindi natanggap o natanggap because they have tracking devices. I think, I am not actually sure about it, but that is my take on it. Kung kailangan pa bang magpa-accredit, I am not so sure about it, but I think it cannot be equated with like bonding company, no? Pwede kahit anong mga courier na ganyan, na registered courier, accredited courier, na may mga devices in order to track whether the mail matter was received by the addressee or not.
Another question, Judge, no? If a counsel elected a particular mode of service, let's say via email, can he still resort to registered mail?
Yes, that is correct. Hindi naman siya, pag nakapili ka, exclusive, ganun lang. So any mode of service will apply. In fact, dinilit na nga yung provision ng priority of service. Inalis na sa provision yon dun sa Rule 13. So wala nang priority. Kung mag-elect ka ng service by mail or electronic service, you can also resort to other modes of service. Hindi man pag nakapili ka to the exclusion of others. There is no such a thing under the rules.
Yes, Judge. Siguro one last before you continue, no? You mentioned a while ago that the lawyer may be deputized to serve summons. So
Yes.
there's a question here. What if the lawyer refuses to be deputized for some valid reason? May the lawyer be sanctioned?
So what is supposed to be a valid reason on the part of a lawyer? So
yeah, Judge, it was not mentioned in the question, no? But
you know what the court would do if the lawyer refuses to follow the order of the court.
Yes. Okay, Judge. So, Judge, in the meantime, since it is now 4:50, please continue with your lecture, Judge.
Okay. So we continue. Let's deal with motions. Okay. There are 3 provisions that I would like to discuss insofar as motion is concerned. Okay. First is non-litigious motions. Okay. Motions which the court may act upon without prejudicing the rights of the adverse party. And it was enumerated several examples of non-litigious motions. Motion for issuance of alias summons, extension of time to file answer, postponement. There you are in section 3 of Rule 15. Okay. Take note that these are not exclusive. Okay. These are not exclusive. These are some sort of examples because the rule says other similar motions will be considered as non-litigious motions. But with respect to non-litigious motion, how should the court act on it? Okay? The motions shall not be set for hearing and shall be resolved by the court within a period of 5 calendar days from receipt.
Yes, yes, yes.
Well, we have technical problems. We are fixing it. And so sorry, but we are fixing it now. Thank you. We'll be back in a few minutes. Hello. It seems the problem is the connection of Judge Hiner. He was disconnected for a while. We will be connecting him again. So pasensya na po, and mahirap po talaga ang live webinar. So we will reconnect Judge Hiner. Thank you.
Hello? Hello? Okay, hello? Okay. So, hello. Can you hear me?
Yes, Judge, we can.
Oh, okay.
Yes.
Sorry, sorry.
Yes,
Okay.
Judge, you're now back.
Yes, I'm now back. Hindi pa naman napuputol ang internet namin. Meron pa. Okay, let us go to section 5, okay, litigious motion. So section 5A enumerated the litigious motions, like motion for bill of particulars, motion to dismiss, motion for new trial, reconsideration, execution pending appeal. There you are. Okay. So, anyway, naandyan naman yung motion, litigious motion. Okay. So, what should the court do with respect to litigious motion? But, wag muna ang korte. If you're filing a litigious motion, what are you going to do? You must serve by personal service or accredited private courier or registered mail or electronic means, okay, a copy thereof to the other party. Okay. And the once received, the other party has a period of 5 days from receipt thereof within which to file comment or opposition thereto. Okay. then the court will resolve within a period of 15 calendar days from receipt of the opposition. Okay. May hearing ba? Wala nang hearing, no? Ang hearing optional on the part of the court, di ba? Ang kinalakhan natin ganito, motion, lagi tayong naglalagay doon ng notice of hearing. Wala nang ganyan. Yung mga litigious motions natin, hindi na natin lalagyan ng notice of hearing because it is discretionary on the part of the court to conduct a hearing, discretionary. The court shall resolve the litigious motion within a period of 15 days. Okay. So let us go to one of the most important provision, which is prohibited motion. Okay. The following shall not be allowed. The following motions shall not be allowed. Number one, motion to dismiss, except on the following grounds. So alam na natin yung kanina, no? Yung apat na ground. Pag lumampas sa apat na ground na yun, lumabas sa apat na ground na yun, then that is already a prohibited motion. Number two, that there is another action pending between the same parties for the same case. So we cannot suspend, and there is a TRO, no? We cannot suspend, okay? Because that is a prohibited motion, okay? Or that the cause of action is barred by prior judgment, okay? Except that is actually the ground for a motion to dismiss. But outside the four, which I have said earlier, prohibited motion ang motion to dismiss. Okay. Motion to hear affirmative defenses, there is no such a thing anymore because that you can find that from previous Rule 16. Motion for reconsideration of the court's action on affirmative defenses. This pertains to action denying the affirmative defenses. No? Motion for reconsideration is not allowed. Motion to suspend proceedings without temporary restraining order. Motion for extension of time. Okay. Motion for extension of time. Motion for postponement, except there are only three grounds by which your motion to postpone may be recognized by the court. Number one, force majeure, acts of God, or inavailability of the witness. Okay, and of course, motion for postponement shall be accompanied with proof of payment of postponement fee. Those are prohibited motions. So they shall be considered a mere scrap of paper. The court will just deny this thing. Okay. So Section 13, these are dismissal with prejudice because there are dismissals which are considered with prejudice. These are dismissal. There are dismissal which are considered without prejudice. Okay. So what are those grounds by which the order of the court will be considered dismissal with prejudice? Okay. Number one, dismissal because of res judicata. Dismissal because of prescription. Dismissal because the claim demand set forth in the plaintiff's pleading has been paid, waived, abandoned, or otherwise extinguished. Dismissal because of the provision of a statute of frauds. If this is the reason for the dismissal of the case, okay, it is dismissal with prejudice, and the remedy is actually to appeal. How about order dismissing an action without prejudice? That is also a final order. But what is the remedy? The remedy is not appeal. The remedy is petition for certiorari. What is our basis? Okay, because it is clearly provided in Section 1G of Rule 41 that an order dismissing an action without prejudice cannot be subject of appeal. So if that cannot be subject of appeal, okay, there is no remedy under the ordinary course of law. Then if there is grave abuse of discretion, you can file a petition for certiorari with respect to such kind of order. Okay. As I have said, Rule 16, wala na yan. Okay. That is deleted already from the rules. The provisions are deleted or transposed to other rules. Okay. So we will move to Rule 18. Okay. Because there is no substantial amendment with respect to Rule 17. Okay. This is pre-trial. Take note that under the new rule, it is not anymore the responsibility of the plaintiff when the issues have been joined to move ex parte for the setting of pre-trial. Okay, it is now the responsibility of the branch clerk of court. If within 5 calendar days from the filing of the last responsive pleading, then the branch clerk of court will issue notice of pre-trial. Okay. So there is a mandate, not only for the court, but also for the parties. Mandate that the pre-trial should be terminated promptly. And what should be done during pre-trial? Okay. The parties are required to mark their respective evidences if they are not yet marked in the judicial affidavit. Okay. They should already examine and make comparisons of the adverse parties' evidence vis-a-vis copies to be marked. So mag-compare na ang original at saka ang Xerox copy kung faithful reproduction. Okay. And during pre-trial, the parties are required to manifest for the record stipulations regarding the faithfulness of the reproductions and the genuineness and due execution of the adverse parties' evidence. Okay. Can you reserve evidence? The answer is yes, but only in the following manner. For testimonial evidence, by giving the names or positions and the nature of the testimony of the proposed witness. For documentary evidence, give the particular description of the evidence. Take note that no evidence shall be allowed if not made in the following manner described above. Okay. So, So we will, when you receive a notice of pre-trial, you would realize that there are 3 dates indicated therein. What are those dates? Number 1, the date of the pre-trial itself. Number 2, the date of the court annex mediation. And number 3, the date of the judicial dispute resolution if necessary. Okay. Take note that the judicial dispute resolution is not anymore mandatory. Okay? The judicial dispute is not anymore mandatory. Okay? It is subject to the assessment of the judge where the case is pending if there is a necessity to conduct JDR. And take note again, ang magkakandak ng JDR hindi na yung judge where the case is pending. A different judge. Okay? A different judge will conduct it. Probably the pairing judge, but a different judge will be the one who will conduct the judicial dispute resolution. Now, please take note that the lawyer and the parties are required to appear during pre-trials, during court annex mediation, and during judicial dispute resolution. Question, paano pag hindi nag-appear sa JDR or sa court annex mediation? The same penalty will impose for non-appearance during pre-trial as provided in Section 5. Ano po ba yung penalty? Pag plaintiff, dismissed ang action, ang complaint. Pag defendant, it will allow the plaintiff to present evidence ex parte. Okay. So, appearance of parties required both the lawyer and the party. Pag hindi ang party, then the one appearing for the party must be duly authorized through a special power of attorney. Okay. Next, okay. Effect of failure of the party to appear during pre-trial, that is very clear already. And we know that already plaintiff dismissed the action, defendant, it will allow the plaintiff to present evidence. Okay. Now, we go to pre-trial order. Okay. The pre-trial order will govern the conduct of the proceeding. The proceedings cannot depart from the pre-trial order, no? Because that will be the contract among the parties on how to present their evidences as indicated in the pre-trial order. Okay? But please take note that dun sa mediation, ang rule ngayon, di ba? The common practice is that during the initial pre-trial, what is the initial practice? The initial practice is that, di ba, it will be referred to mediation. Now, not anymore. Why? Pre-trial shall first be conducted. Pre-trial shall first be terminated before the case can be referred to court annex mediation. And take note, 30 days lang. No extension shall be allowed. What about judicial dispute resolution? It will only be There will only be judicial dispute resolution if the judge of the court to which the case is originally referred is convinced that settlement is possible. Okay? If the judge sees that there is possibility of entering into amicable settlement between or among the parties, then it will refer the case to a different judge for JDR. Otherwise, wala nang JDR. Ang period ng JDR, 15 days lamang, non-extendable. Pag failed, then back to the original court. Okay. Now, what is this judgment after pre-trial? Okay. Take note that dalawang issue sa isang litigation, di ba? Factual issue and legal issue. Ang sinasabi lang sa Section 10, if after pre-trial, wala ng factual issue, then the court would have to decide the case either through summary judgment or judgment on the pleading when there is no more genuine issue. And the same will be indicated in the pre-trial order that the court will render judgment on the pleadings or summary judgment since there is no more genuine issue of material fact. The court can actually do that. And I have been doing that when there is no more actually issue with respect to the facts of the case because everything is admitted with the parties. So the court can already decide the case because there is no more need to present evidence because everything almost is admitted. That is what Section 10 is telling us. Okay. So we move to the last. This will be the last item. No, it will only take 10 minutes. We move immediately to Rule 30 because insofar as Rule 19, okay, Rule 19 up to Rule 29, no, may mga slight amendments, but the amendment is not substantial. But we move to Rule 30, the trial. Okay, this changes everything because, as we have said, the continuous trial system were actually implemented in civil cases already. Okay, so we move to Rule 30. Okay, Rule 30. Trial. Okay. Okay. So, as I have said a while ago, you must take note of your pre-trial order because it is provided in Section 1 of Rule 30 that the party shall strictly observe the scheduled hearings as agreed upon and set forth as set forth in the pre-trial order. Okay. So, this is the schedule of trial, no? I have made a diagram for easy appreciation, okay, instead of reading the provision. Okay, so this is actually the trial process. Okay, the court will schedule the trial, okay, within 30 days after the termination of the pre-trial. Okay, what is the period of time for the plaintiff to present its evidence? Within a period of 90 days. Within a period of 90 days, the plaintiff must be able to terminate the presentation of its evidence. Okay. How about the defendant? The same. The defendant, 90 days. Okay. When there is a third-party claim, counterclaim, cross-claim, okay, it must be terminated. They must be terminated within a period of 90 days. Now, question. What, Judge, yung ba ay 30 days for the third-party claim or 30 days for the counterclaim or cross-claim? No. Okay? 30 days, 90 days is devoted to terminate the presentation of evidence with respect to those claims. No? Bahala na ang court kung paano i-divide yun. What the rule is saying is that it should be terminated within a period of 90 days. How about rebuttal evidence? It should be terminated within a period of 30 calendar days. Is this rebuttal for the plaintiff or for the defendant? All rebuttals for the parties, if there is, no, must be terminated within a period of 30 days. It is also, and then after the case is submitted for resolution, the court shall decide the case within 90 days, no, within 90 days from the time it is submitted for decision. Take note that we are mandated to finish or to terminate the presentation of evidence for the parties within a period of 300 calendar days. Now, If there is no third-party claim, fourth-party claim, okay, the period of trial will be reduced to 6 months or 180 days. If there is third-party complaint, fourth-party complaint, we are bound, the court is bound, to terminate the presentation of evidence for a period of 300 calendar days. Then after the case is submitted for resolution, then within 90 days, the court must render judgment. So that is the trial process as provided and mandated by Section 1 of Rule 30. Okay. Adjournment, okay, the party who caused the postponement is warned that presentation of its evidence must still be terminated on the remaining dates previously agreed upon. Okay. Then, insofar as Section 3, no substantial amendment, ito namang Section 4, it's just a reminder to judges to start hearing at 8:30 in the morning and 2 o'clock in the afternoon. Okay. All courts shall ensure that the posting of their court calendars, we know that already. Okay. So the order of trial. Okay. So that is provided in Section 5. Wala namang pagbabago sa order ng trial under the old and the new. So I just put here for easy reference, okay, the order of trial. Okay. Of course, the plaintiff will present evidence on his claim. Then it will be the turn of the defendant to present evidence on his defense as well as his cross-claim and counterclaim. Then it will be the turn of the defendant. Then it will be the turn of the fourth-party defendant if there is any. And then the turn of a parties against whom a counterclaim, cross-claim has been pleaded. If there are rebuttal evidence, then the parties will be allowed to present rebuttal evidence. Then it will be submitted for decision. Okay. Take note that there is no such thing anymore as written formal offer of evidence in civil cases, just like in criminal cases, no, applying the guidelines for continuous trial, oral offer of evidence, oral comment, and oral ruling from the court, subject to one-day examination rule. Okay, so Section 9, Section 8, there is no substantial amendment. Okay, Section 9, okay, and that's it. No, with respect to 35 and the rest 31 to 35, there is no substantial amendment except that the court can motu proprio render judgment based on the pleadings, no need for motion, as well as the court can render judgment based on the based on summary judgment without need of motion from the other party. That is the amendment in the succeeding rule. Okay. But before I forget, nakalagay din ito, no? Yan. Submitted for decision. Take note. Within this one. Okay. Yan. Within 30 days, the court shall decide. Not only that, within 90 days, the court shall decide, and within 90 days, dapat ma-serve ang judgment. So, ano ang bakit? Kasi, meron kasing pwedeng mangyari, no? Na actually matagal nang hindi nadi-decide, pero pag lumabas ang decision, ang date within 90 days pa rin. Nahuhuli yung mailing. Ngayon, para to evade such kind of situation, ginawa ng Supreme Court, within 90 days you decide, and within 90 days, you mail the judgment. You serve the judgment. Okay? So, thank you very much. It's 5:20. We can still entertain some questions if you have. Hello?
Yes, Judge.
Yes, yes. Oh.
We have questions here, Judge. No, may we call on Attorney Maria Redor if you have a question?
Oh, at any rate, Chris, no?
Yes.
We have received online several questions. We will try to respond them, considering for lack of material time, we'll not be able to address them. No, but we have collated the questions from the participants, and we will try to address them. With respect to my presentation, I will just send it to Attorney Hines, to Manong, and as to how it will be distributed, I really don't know, but I will send the copy of my presentation to
Yes, thank you, Judge, and thank you very much to those who asked their questions. No, as mentioned by Judge, no, we will try to request, no, Judge, to answer all of them, and then we'll try to give you, no, the answers. Thank you.
Okay.
Okay, Judge, thank you very much for your exemplary lecture. Ladies and gentlemen, kindly join me in giving a big round of virtual clap to our Judge Hiner. At this point, may I request and call retired Justice Francisco P. Acosta, Secretary of the Commission on Filipino Overseas and President of Beda Law Alumni Association, to award the Certificate of Appreciation to our very learned lecturer.
Citation, the certificate. Hello?
Yes.
Yes, Justice, you are on video already.
Okay. This certificate of recognition is awarded to Judge Hiner M.Gito, LL.M. D.C.L, in grateful recognition and appreciation of his indefatigable service and exemplary online lecture on the amendments to the 1997 Rules of Court Procedure, given this 14th day of May 2020, signed myself and Attorney Wilson and Hines, President, Beda Law Batch 1995.
Thank you very much, and congratulations, Justice. Congratulations, Judge Hiner, and thank you, Justice Nick. May I again call Justice Nick to deliver the closing remarks. Thank you very much.
Well, mga kapwa ko, bidista at mga kompanyero at kompanyera, magandang hapon sa inyo lahat. Yung lecture ni Judge Hiner is really divine intervention. It was very successful and very productive. The lecturer was not only brilliant, handsome, and irresistible. Hindi ako makatulog, hindi ako makapagnap dahil his voice resounded with authority and clarity throughout the lecture without faltering or wavering. Most importantly, his generosity in sharing his expertise gratis et amore is most commendable. It is truly inspiring and exemplary. Maraming salamat po, Judge. The lecture is free. It is also COVID-free, and it is also stress-free because we don't have to account for our whereabouts. We are in a legitimate company of our distinguished compañeros. And thanks to Beda Class 1995, represented by Attorney Winston, for sponsoring this event. It is really a landmark in legal education. And the Ayala Corporation, represented by Attorney Moner Mosura, and Kevin Barfield. But last but not least, we have to thank our Supreme Court under the leadership of the Chief Justice for coming up with the amendments which aims and effectively expedites the disposition of cases from service of summons up to the trial proper. So it is streamlined litigation, and it will really help in the speedy disposition of cases. Lastly, I am sure that Jerry Parulan has attended this lecture. He is the chairman of our alumni committee on MCLE. He has proposed an online MCLE by our alumni. And this lecture will really inspire us to continue with that project. Thank you very much. And I hope that many lectures of this kind would be held in the future. Maraming salamat po.
Maraming salamat po, Justice Nick. Thank you very much to all who participated. And magandang hapon po sa inyong lahat. Bye!
Bye!
Finally.